shadows, axes high, shields strong. From distant lands we gather, hearts of fire all along. Obey cause we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Ho, 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 says Santa Claus.
He's not an idiot. He's just Swedish.
Heyo! I'm just having fun with my intro and stuff and everything. Hello, folks. Hello, folks. Welcome to Slightly Bust Friday Law Show. Where is my... Oh, I have to use that. Welcome to Slightly Bust Law Show. We are going to watch Laura Owens making an ass of herself, which is apparently quite common. You might even say she is an expert at it. We are going back in time a bit because I'm still familiarizing myself with the case. So I have... Let's see, where is it? Did I lose it? No. Where is it? The October 24th hearing is what we are going to watch today. As per usual, we have the Wheel of Regrets in play. Rules of engagement is that for every $50 in super chats, gifted memberships, PayPal, or buy me a coffee, gets you a spin on the wheel. So yes, this is somewhat of what people might call drifting stream. I do need one once in a while. Now, this time I'm trying to not fall asleep after 3 hours of you guys getting me drunk. At least I will try to. And we have Mr. Jingles here. Hello. So he's here watching you guys, making sure you behave and making sure I behave because he does such a tremendous job. So yeah, it will be me, Mr. Jingles. And if somebody, I sent out the link to a bunch of people. If they can, they can. If they can't, it will be just me and you. But this is what we're here for. The Owens versus Clayton Echard. This is from October 24th, 2023. I don't know what's going on here. I see that he has not an attorney for some reason. Yeah, you got me real bust last Friday. You did your job. I provided entertainment. And we will see how we manage this time. So, without any further ado, let's get into it. There, and we will see what we get out of it. And down to the left is Laura Owens in the way we prefer her, not showing her face. Oh God, there she is. Ah! Oh, she did that so she would be in the upper left corner. Oh, she didn't want to be on the bottom, which is interesting because she's very, very used to being on her knees. Oh yeah, that is one thing that you guys need to be very, very clear about when it comes to the law. sometimes, unless you have help, truth will not set you free. You have actors out there that absolutely play the system. And remember, Laura Owens got away with it for just about a decade. But then she took it one step too far. But she's still ruining lives. Still ruining lives. Trying to, at least. And so, yeah. As long as you tell the truth, everything is going to be okay. Yeah. That is what a lot of people think when the cops come knocking at your door and say, "We just want to talk to you." And moments later, you will be in handcuffs because you thought, as long as I tell the truth, they will not twist it back at me and use it against me. They will.
Unable to hear you. Hi, Commissioner. We're unable to hear you.
Do we have good sound, everybody? Do we have good sound?
Okay, there we go. Sorry.
I need to know.
All right, we'll start again. Sorry. I'm Commissioner Joe Kestis. We're here in the matter of Clayton Eckhart. Am I saying that right now? Eckert, sorry, versus Laura Owens. This is CB 20230533952. We'll begin by having everyone state their name. Mr. Eckert, if you can state your name for me.
Clayton Eckert.
Right, counsel?
Yes, Your Honor. Attorney Joshua Lopez representing Laura Owens, who's present via Microsoft Teams.
Thank you, Ms. Owens. If you can state your name for me.
Laura Owens.
All right, thank you.
That's not
We're here today regarding
Gingrash.
the pre-issuance hearing on a petition for an injunction against harassment that was filed by Mr. Eckhart. And so we have an hour and a half for the hearing. That means each side has about 40 minutes to conduct their case and their testimony. So you do want to make sure you're being conscientious of what you want to present in the time that you have available. We do have a number of exhibits. And so if you would like to use an exhibit or admit an exhibit, then you do need to lay some, what I'm going to call foundation for that exhibit, which means you need to tell the court what the exhibit is, if there's a specific date and time that relates to that exhibit, how you have knowledge of the exhibit, and how it's relevant to what we're doing. And then you need to actually move to admit the exhibit.
Oh, this Josh was about 4 long before Gingrash.
Move to the court to ask to admit the exhibit. Just because you submitted them doesn't mean they come into evidence unless you move to admit those. Okay. And then
thank you, Laura, for hiding more of your face.
So, Record, you're going to go first because you're the plaintiff. You'll present your case and your testimony, and then the other side counsel will have the opportunity to question you, and then they can call witnesses, and you'll have an opportunity to question them, and then at the end, everyone will have an opportunity to make a closing argument. Okay. The things that people can testify about, you do need to make sure that they are related to something that you have personal knowledge of. So you can't just say, I saw something on the internet, and so now I can testify about it. Okay, it doesn't need to be something that you have some personal knowledge about. And I know that this case also has a family court matter. This is not the family court case. This is not the trial on the family court issues. So I need everyone to focus on the issues that we have for this hearing. So we're not deciding pregnancy issues, we're not deciding paternity issues. Those are not the issues that are going to be decided today. So what this court is looking for is a determination as to whether or not there were a series of events that were aimed at a particular person that would cause a reasonable person to be annoyed, alarmed, or harassed, that that person was in fact alarmed, annoyed, or harassed, and that those actions had no legitimate purpose. Those are the findings that the court is looking to make. So, record for you, you're trying to show by preponderance of the evidence that that was the case. And then, obviously, Ms. Owens is going to be trying to show that there is not a basis for the injunction. So the things that are outlined in the petition are the things that can be discussed or addressed, okay? But as I said, you know, we're not discussing whether or not officially that there's a pregnancy or whether or not officially there is a paternity issue, okay? So we need to make sure that we are keeping on track with what we want to show in our case. So the series of events does need to be more than one, but it can be over any period of time. So those are the things that we're looking for. Does anyone have any questions about what I've just gone over?
Your Honor, I have a couple questions.
Okay.
Did you want to hear opening statements?
I mean, I would allow people to do an opening if you wanted to, or you can waive openings either way.
Okay. And my other question is that what I believe that Mr. Eckert is going to present are emails regarding alleged harassment in this matter. But the emails, and I know you had indicated that, I understand this is not the family law, the family court case, but the emails and the alleged harassment have a lot to do with paternity and things of that matter. So I think that those things are going to come out despite this not being us trying to prove paternity and things like that. I think the content of the emails has to do with that, and so those things will come out.
And I understand as they relate to the specific basis for the communication,
Okay.
that they can be brought out. I just don't want the parties to think that I'm going to be making any determinations as it relates to those other issues.
Thank you.
So do either party wish to make an opening statement?
No.
Or we can just begin with the testimony.
Present my evidence. Your Honor, I'd like to make an opening statement.
Okay, go ahead.
Your Honor, you're going to hear that back in May of 2023, Laura Owens and Clayton Eckert became intimate, which led to my client becoming pregnant with twins. And since May of 2023...
Oh, we already know that was a lie. Because, well, getting from there to up your hoo-ha, yeah, that never happened.
Clayton has refused to believe that my client became pregnant. He's refused to believe that he's the father of these unborn children. And he has refused to work with my client to create a plan on how and if he wants to be a part of these future children's lives. Instead, Clayton turned to the internet. He's turned to his fans, he's turned to his followers, and he's spread rumors and lies about my client.
Oh, really?
Clayton has insinuated that my client lied about being pregnant. Clayton
Yep.
posted online about legal issues he knew little about regarding my client, Laura Owens, and a legal battle that she was involved with and is still involved with another individual. Clayton has posted about
With
Laura
at least 3 other
that
individuals.
has led to harassment by his fans and followers.
Oh,
Laura has received harassing messages. Laura was asked to kill herself, and Laura has been staying inside to protect herself, which is why she's currently appearing via Microsoft Teams for this particular proceeding.
and you
again,
can
this all
show
stems
this?
from Mr. Eckert's post online. All communication from Laura to Clayton during these time periods that Mr. Eckert put in his petition has been related to Laura's pregnancy with Mr. Eckert's unborn children. It's also been related to what Mr. Eckert would like to do moving forward with the unborn children, creating a parenting plan, and actually it's also in regard to potentially him taking down posts, which again led to harassment by his fans and followers. None of the communication that Laura directed at Clayton was for harassment purposes. All the communication was for legitimate purposes, and a reasonable person in those same circumstances would not be seriously alarmed, annoyed, or harassed by that communication. And at the end of this hearing, we're going to request that the injunction against harassment be dismissed or not issued. Thank you.
So for testimony purposes, Mr. Eckert, I'm assuming you're going to be testifying, and then Ms. Owens, I'm assuming, is testifying, counsel.
Ms. Owens will be testifying, Your Honor.
So if I can have you both raise your right hands, you can be sworn in for me.
Yeah, by December 12th, this guy was gone.
You're about to give will be the truth.
Less than 2 months later, he was gone.
Yeah. You? Okay. All right. Mr. Eckert, if you want to go ahead and begin with your presentation of your testimony.
Thank you. I think it is important to just provide a little bit of context for the opening statement. It is what he had stated. I do not believe that Laura is pregnant. I know we're not here to discuss that today, but because of the evidence I will present, I'll explain why I've been receiving unwanted messages for the last 5 months, and I have blocked this individual from all communication, yet they continue to send me messages. And I have asked this individual to early on do a paternity test, and she said she would not do it unless I were to date her exclusively. And so then Ms. Owens threatened to go public, which I have submitted that evidence today. But my reasoning for why I doubt her and why I have chosen to cut off all communication is because, if I can submit Exhibit 32.
And what is Exhibit 32?
So Exhibit 32 is an ultrasound image that I was sent via email by Laura.
Oh.
No ultrasound report was provided. And when I asked to speak with a doctor, she would not allow me to talk to that doctor. We also did an early resolution conference. It was in the last couple weeks. The mediator asked for her to make that phone call to that facility to prove that she and Dave had to do this ultrasound. She did not do it. She was not willing to make that phone call. And so with that picture and that picture alone, I believe it is photoshopped, and there is no report that she has been able to provide. And I've asked.
Yeah, and later on, she admitted that she doctored it. And then somebody at Megan Fox, on one of her live stream, was it? They discovered that ultrasound she nicked from a 5-year-old video on YouTube with the watermark still on.
For it, and I would like a doctor to be able to stand behind that image, as I believe it's a fraudulent medical record that she has submitted to me via email.
Okay. Are you moving to admit Exhibit 32?
I would like to admit, yes, Exhibit 32.
Any objection?
Yes, Your Honor. If I'm not mistaken, Exhibit 32, double check.
She has a resting bitch face if I ever saw one. I mean, as soon as she relaxes her face.
You know what, actually, Your Honor, I'm not going to object to this.
All right, 32 will be admitted.
Thank you. May I continue?
Is she
Okay.
trying? Is she trying to show both her face and her belly at the same time, and it only shows her flat chest?
I would also like to admit Exhibit 36.
And so,
The flash
before we get too much further, if you can just explain to me what you believe your relationship is or was with Ms. Owens, because part of the reason it's an injunction is because of the relationship nature of it. I think that you listed as being not an intimate relationship. So I guess maybe if you can clarify that for me.
Yes, Your Honor. Laura and I had engaged in oral sex one time. And to me, as I filed this, I did not believe that constituted a relationship of any kind, as it was a one-time thing.
Okay, thank you. All right, go ahead, sorry.
Exhibit 36, I would like to admit that as well. This is a flash drive file. This was also sent to me by Laura Owens via email. She, in this email, which I actually have, can I submit multiple at one time or no? Or reference them at least for now?
Okay.
So Exhibit 18 is a screenshot of the email that she had sent me with this ultrasound video that she claimed was, you can see on there, I don't know, 1,000,000% real ultrasound video. She's claiming that that was the ultrasound of our children. But then I uncovered the Exhibit 34. This is a YouTube video from over 6 years ago. And that video has the video that she sent me within it.
Oh, so he discovered it.
Exhibit 36 is the video that she sent me, and then the video on YouTube. And as you play both of them out, you can see that they are identical videos. She had cut a portion from the YouTube video and claimed it to be her own when it was somebody else's. And so I would like to, I'd like to admit at least Exhibit 36, but also 34 and 18 to prove that she did in fact send this to me via email, and as 18 and 34
Thank
show.
you, Catherine.
But also then to admit 36 because that is the visual proof that these videos are identical.
Any objection to 18?
Yes, Your Honor. I don't think there's enough foundation for the different things that Mr. Eckert is stating. It sounds like something was sent to him, and I don't know what websites that he's going to get these. And the things that he's claiming in here, he's saying that these are identical. I don't know if he can testify that these are in fact identical.
Okay.
Yeah, this is why you need an attorney who then, well, upon information and belief is the phrasing of it, and on the court's discretion, you can examine this evidence. If you want me to provide expert opinion, yada, yada, yada. But first, thank you to Catherine for your $5 Canadian with a piercing. How's it going? It's going great. It's going great. Thank you so much for your super sticker. That brings us to, well, I know how I don't know what the rate is between US and Canadian, but since it's the first one, I will count that as a $5, so, which brings us to $45 to the next spin on the Wheel of Regrets. That was an interesting freeze frame where she is the theater of Laura Owens when she tries to. She can't have both her fake belly and her face on screen at the same time. So she does this rubbing, and then she sits down so her face can be, and then she stands up to rub her belly. Oh, thank you, Denise. It's on Dave Neal's video that Megan and Dave found the watermark. A chat member identified it as Fiverr. Oh, that's so good.
18 appears to be kind of a screenshot of almost similar to 32, but I think it's closer to matches 34. But I think 18 is the one that actually was sent to him. Is that correct?
That is correct.
So do you have a specific objection to 18? Or objection
If that's what was
to
sent
more
on-
related?
Yeah. Wait, 17, 18.
18, I think, was the one that was sent to him. So do you have something specific about that exhibit?
You see how she tries to stretch up, and she does the belly rub.
I mean, maybe just some foundation regarding who it was sent from and how he knows. Got it.
Hi, Wendy. Hi, Wendy. Good to see you. And she leans
You
forward.
can just outline for the court specifically the way that you received this.
Yes, I was sent this by Laura Owens. As you can see in the screenshot, this was sent from her.
What date?
The date of it was October 6th at 4:39 p.m.
The judge does give
Any
him a little
objections to
leeway.
18?
There you are.
18 will be admitted. And then 34, give me more information about when and where you received this document.
So Exhibit 34, I uncovered as I had questioned the validity of Exhibit 18, what she sent me. I did not believe that it was in her ultrasound. So I started to look online and I found this YouTube video. And upon playing it, I found that the video that she had sent to me is within that YouTube video.
Okay. Objections to 34.
There you are.
34 will be admitted. And then objections to 36.
It's good that he did
Yeah.
both the screenshot,
36.
the address to the video, and then the side by side. All right. PayPal. Yes. Yes, I know, Wendy. Thank you so much. Oh, 25. That is so generous of you. Thank you so much. Thank you. Oh. I need to get myself to California some of these days. Not this year, because this year is all Utah and Miami. Maybe next year. Are you in need of a Viking Santa in California? Just checking. Thank you so much. Let's see here. That gets us to $20 left to the next spin on the wheel of regrets. Nick, when you come to California, I'll host you. I'm near Sacramento. Geography and me, I will find it.
Will be admitted. Record if you want to continue.
Yes, I would like to. I would also like to discuss Exhibit 30. So Exhibit 30 entails a prior court case with this individual. And the reason why I bring it up is because of the repeated or similar patterns of behavior that Ms. Owens has exhibited. In this exhibit, there is an ultrasound in which she presented to this individual, and then it was found that through a reverse Google image search that she had taken that from online as well. In this case as well,
good research.
States that she became pregnant
Clayton.
by this individual, and she also claims that she was became pregnant with twins after one sexual encounter. And
how about that? And with that, thank you to Wendy, getting us to the first spin on the wheel of regrets. Dun dun dun. Boom. And it's a gin shot. Let me see. Okay. It's a shot of gin. And I will use my Kentucky shot glass. I did this when I drove through the United States, south to north, starting in Houston. I went to New Orleans, up to Atlanta, up to Chattanooga, and another city nearby, and then Indianapolis, and then up to Detroit. So every state I passed on the way up, I bought a shot glass in. So I have a bunch of shot glasses, and here is the gin. It's a Japanese gin, Roku gin. Roku. Thank you so much. Thank you to Wendy. Thank you to Catherine for contributing to the first spin on the Wheel of Regrets. Cheers. Ooh. Now, I do have not just beer to alternate with, because they had a sale of Mountain Dew at my local Lidl. So I will have some non-alcoholic drinks this Friday, because I really don't want to fall asleep again on stream. Thank you so much. Thank you so much. Whew. All right. Back to the fusterclock.
So the parallels between my case and this individual's case, I think is important to bring that to light and admit that as well, because this individual has displayed repeated patterns of behavior. And I think that's important to note as to why I question the validity of this individual's claims.
And where did you obtain this document?
I obtained this document from this court. I came in here, it's publicly accessible. So I came here and I searched it, and there's about 14 pages in this that I printed off. There's more in the court system, but I consolidated it to bring out the documents that referenced similar instances.
Well done, Clayton. This is good research.
She had brought this claim against also questioned if she was pregnant or not. It does state in here that she provided sonographic images, and then a reverse Google image search revealed the images were identical to a sonogram found on a blog post from 2015. And then within this document, it shows the pictures that were submitted to the court, the ultrasounds in question. And then I'd also like to bring to, in this document, in the picture, it says that she'd sent to him, it looks like you're going to be a dad to one or two.
By the way, later on, didn't she claim she was no longer pregnant at this point in time? That she had a sudden ejection in July? And there she is rubbing her belly.
Babies. And so she again states that she was pregnant with twins with this individual. And then on one of the last pages of this document that I had pulled out, it was noted in this court case, the plaintiff reportedly fabricated a pregnancy and subsequent abortion in the past during a relationship with a Michael Maraschini in 2016.
Yeah, Mr. Maraschini, she is still, to this day, almost a decade later, she is still bothering him. Next Friday, I will hold a proper fundraiser for Mr. Maraschini's defense fund. Next Friday. Next Friday, we will have similar things. I hopefully will have a bunch of guests. And then we will try to fill up Mr. Maraccini's Gives and Go Defense Fund. Okay, that's next Friday. This is this Friday.
Not know, the specifics of all of these cases, but I do want to bring this to light and submit it admit the exhibit because of the repeated patterns of behavior that I think are important to note, because contextually speaking, that is part of the reason why I will then present my evidence towards why I feel I'm harassed, because I do not believe what this individual is stating. I don't believe anything that she's saying, and these are the reasons why.
Your Honor, I'm going to object to this being entered. This is an ongoing case. We don't know what claims are or are not true within this exhibit. I don't think that it's appropriate, and I don't think that it's relevant to Mr. Eckert's petition in this specific matter.
So one of the allegations is a pattern of behavior of accusing men of getting pregnant in his petition. So I guess that's what he's presenting it for. So
No, Laura.
Ms. Owens, just a minute. I think that's one of the allegations in his petition, but
again, Your Honor, this is an ongoing case. We don't know what the result of this specific case regarding this exhibit is. We don't know anything about this case. We have it looks like this is some sort of complaint. It looks like it's a motion to dismiss, I'm sorry. Or there's several documents here. I don't think that this is relevant for this particular case. I think that this is speculation. These are claims that other people have made. I think this is hearsay. I don't think it's
Yeah, the problem here, I see what you say here. Problem here, it's still ongoing. There's no, but if there is a ruling within that case on these images, then he might be able to use it as a pattern of behavior. But if it's not, because that judge is waiting, then it might be an issue. I don't know. I haven't seen this.
admissible for this type of hearing.
all right. So I'm not going to be able to admit Exhibit 30. I do agree that there's not, this is a complaint and a motion to dismiss, but whether or not there's significant information enough to be able to support that, and whether you have any knowledge.
This is where a lawyer should have had in, I want you to take judicial notice of it. It's not admitted as evidence in this case, but to have a judicial notice, meaning that the judge can add weight to it.
Of it is I think I'm not going to be able to admit that exhibit. Ms. Owens is raising her hand, but your attorney is here. So did you have a question?
No, he covered everything.
Yeah,
Okay.
so shut up.
And he's going to be speaking on your behalf unless you're testifying. So
I would like to
Okay.
testify.
you don't have your chance to testify, but you can't testify in the middle of his testimony, and then your
Right.
attorney needs to be the one that speaks on your behalf unless it's your testimony, okay?
Okay.
Which you should know by now, because you have a multiple
Yes, now I'd like
court
to
cases.
go in and admit each of these documents, and I have them set in an order. So the very first one, Exhibit 1, this is just showing all of the files that I have accrued. There's often 2 to 3 emails that she sends me a day. She started sending me emails, harassing emails on the 6th of June, and she is still sending me emails as of yesterday. And so Exhibit 1 is just showing the frequency of her harassment from a bird's eye view.
And so when you get the email from her, tell me how this gets created.
Yes, so when she sends me emails, I screenshot them and then I place them into these files so that I have them for a record.
Okay. Any objection to Exhibit 1?
Yes, Your Honor. Again, I don't think that the frequency of emails is something that would indicate harassment without something more. If there's communication back and forth between emails, then the frequency of it, of how many times somebody sends an email, I might send 60 a day, but the frequency of emails between, I believe, May to now, and I don't know how many these are. We don't see the emails in here. There's nothing to say that this, in fact, is harassment within the meaning of the statute. So for those reasons, I'm objecting to this.
Well, that's the point
Okay.
of this
For the
hearing.
objection, I'll admit Exhibit 1.
Ah, good choice, Your Honor.
Thank you. Can I continue? Exhibit 2, a lot of these next exhibits are all going to be phone numbers that Laura has contacted me from. She has contacted me from 13 different phone numbers, and I finally stopped blocking the 13th one because I knew that she just would continue to create a Google Voice phone number. And so this first one, it says in the text message, it's Laura, please unblock my, and then she shows her number. That was her original number. And so I would like to admit these one by one to show again the many different times that she has continually contacted me after blocking her from different phone numbers.
So this is a text message from when, do you know?
Unfortunately, I don't. It just says text message from today. Again, I was screenshotting these as I received them. I received these over the last 5 months. As far as what exact day, I'm not right now. I'm not aware, and I don't know if there's.
Can you approximate when this message came in, or you don't know?
To be honest with you, Your Honor, as far as when this one came in versus the other ones, I don't know. This one says, I have it down here as her blocked cell number 12, so this is probably one of her last ones that she had sent to me. And I would say that I think this one came through probably about a month ago, because since then she resorted back to sending me emails because she put a mail tracker on the messages. So she was able to see when I was reading them. But during this period of time, when she was sending these text messages, I was not opening her messages. And so she knew through her mail tracker that I wasn't reading them. So she decided to go
And she stands up again to rub her belly.
Manner in order to get them to me, because she was
Theatrics.
not opening her emails.
Okay, so you have this one, you believe is from one of the 12, at least one, the 12th message, that as well as cell phone number that she was using.
Correct, yes. Each of these came from Laura, yes.
Okay. Any objection to 2?
Yes, Your Honor. Again, Mr. Eckert must show that there is harassment. When I look at this text message, I don't see anything that is even remotely close to harassing here. It's a text message.
The harassment is different numbers, the amount of different numbers going back to emails. It is, I hate to use this expression, but it is the totality that constitutes the harassment, not each individual.
Indicating to him that they're having a boy and girl. She has an ultrasound to show
the fake ultrasound
in here that is even related to the petition itself that shows that this is harassment, that he was annoyed, alarmed, harassed in any way. This is simply a text message.
Well, I mean, part of his, petition is the high volume of those, and that ultimately he can testify whether he was annoyed or harassed by these. So I'm going to admit Exhibit 2 over the objection.
Thank you. Again, Exhibit 3, just to make this, again, I want to be respectful of everyone's time here. This is, again, another cell phone that she had contacted me from, so I'd like to admit this one as well for the same reasons as Exhibit 2.
Your Honor, it sounds like there's going to be a number of different cell phone screenshots submitted to the court, and I just want to make record straight that I am objecting to all of these based on the same reasons I was objecting in Exhibit 2. So,
Okay. So
I don't have to just repeat myself over and over again.
all right. And so This exhibit 3, it has that similar language to police and block the original number. So you're telling me this came from Laura, but from another block number.
Correct.
All right, I'll admit 3 over the objection.
Thank you. 4, also sent from Laura. This one says that she couldn't get into Google Voice, had to make a new number. So again, this one just shows that she was in fact using Google Voice and creating more and more numbers in order to harass me. And yes, I did feel harassed because I did not want these messages. This one you can see I did respond to, and what I said is how I felt. I was asking for her to schedule the paternity test, which she continuously declined unless I were to date her exclusively. But for the purposes of this text message, it was another unwanted text message that she had sent my way.
So tell me a little bit more about the dating thing, what you're telling me when you say that.
Yes, so you can see this in this exhibit here. She said, guessing you won't read this, but I made you a pretty good offer. Meet up tonight to discuss the pregnancy and the possibility of dating. But regardless of the outcome, I will schedule a test with Ravjin tomorrow. So her stipulation for taking a paternity test early on has always been that she would only do the test if I were to date her exclusively for 2 weeks. Then she dropped it to a week, and I did not agree to any of that. I simply just said, as it says in here, drop the dating stipulation, schedule the test, pay for the first part of it, then email me when you schedule it, and I will schedule my part. So I had continuously tried to figure this out, and she would not do the prenatal paternity test unless I were to date her.
And this Ravjin is the?
Ravjin is it is the facility that provided the test so that you can test for a prenatal paternity test for twins.
Okay. All right, I'll admit 4 over the objection.
5, again, is another text message from her again, saying that she doesn't know how to use this app. She's referencing Google Voice. She said, I'd like to meet, no strings attached. I did not want to meet with her. She's asked me to do multiple times. I do not feel safe meeting with her because I'm not sure what she would claim if we were to meet up. I don't have any reason to meet up with her. So this is another text message that she sent me that was unwanted and very harassing.
Over the objection, I'll admit 5.
6, again, another text message says she changed her number. I would like to admit this one as well for the same reasons as the previous messages.
All right, and this is another different number than previously used.
Yes, and then in this one, I would even just like to highlight, she said she threatened to leak this to the media, which I will be admitting in evidence for that, but she threatens to go to the media, which she ended up doing. This text message just proves that she was, again, looking to defame me through basically whether we date or leak this to the media. She threatened me to go to the media with this text message, amongst other times she threatened me.
All right, I'll admit 6 over the objection.
7, similar thing again. She stated this time she would do it with no strings attached. I had then responded by saying, let's schedule the paternity test regardless. But she was asking for this agreement and that we needed to meet up for a good faith consultation. Again, I did not feel safe meeting up with her one-on-one. So I disagreed with this, but this is another text message that she decided to send from a different number.
And she keeps this standing up, sitting down.
One of these, as you can see at the top, they're all different numbers. So
pure theatrics.
From a different number every time.
I'll admit 7 over the objection.
Clayton is doing
Another
really
text
well
message,
here.
She just states that she sent an email to Ravjin, and then she threatened, you want me to go to the public instead of meet up? So those were the options. Either we meet up or she goes public with the information.
I'll admit 8 over the objection.
9, another message that I didn't block. As you can see, she sent multiple messages before I decided to block her. And she was asking for a good faith consultation. Again, she was trying to meet up with me. For what reason, I can only speculate, but I did not feel comfortable doing so. And so this is another phone number that I ended up blocking.
And can you elaborate on what it says? I just made what I think is a very enticing offer. What that means?
So to be honest with you, I don't remember exactly what her offer was. She made multiple ones, but they all centered around a very similar, if we meet up and we tried to date, it was 2 weeks, and it became 1 week, then it became just meet up for this tonight, this good faith consultation.
I don't know when Laura's next
once we do this,
court date
take
is.
the test. But again, I did not feel safe being with her one-on-one. I did ask actually to meet up with in the courts, or I said we could even meet up. At one point, I said a coffee shop where people were around, and she declined that and said, no, we need to meet up in private. So I said no to that, and blocked her again on this phone number.
I'd hold at 9 over the objection.
Again, 10, this is another phone number. She mentions going dark on her, which is a reference to me not responding to her. Again, just to highlight that she has been consistently harassing me with me not responding to her for the large majority of these messages. The only time that I was often responding was to try to get a paternity test scheduled. Outside of that, I did not. I had little to no interaction with her. And so at this point, she references here, I will cancel the Rabgen appointment. She had scheduled one, paid the $750 for it. But then in the past, as she had stated she'd scheduled it, she would end up canceling these. So it was just a show on her side of things to state, yes, I'm trying to do this test. But when it came down to it, she always placed stipulations whenever I responded to her. So at this point, when she said I'd spend $750, I did not respond to this and block this phone number because I was not taking any of what she was saying seriously. Because she can, every time I would ask, okay, let's do this, she'd bring a stipulation on board.
Submit 10 over the objection.
11. So again, similar thing. I think this is around the same time. She said she'll tell Rabgen that we don't want the appointment next week. But I couldn't be more steadfast in my decision not to take it earlier without the stipulation. So again, the stipulation is the only way, as she says here, and then she says, anyway, I hate to go to the press, but that was your decision as well, and I respect it. And then she even says, she tries to talk about making an offer on a property for real estate. But so again, I don't understand why, as clearly there's no relationship here or any interest in me wanting to talk, but yet she was trying to have any type of discussion with me. But again, she says here stipulation is the only way to do the test, and so I end up blocking her again.
That was mid 11 over objection.
12, again, this one, she said she wants to do the test. I then said, you want to do the test and the stipulations? She said, you're going to be forced by the court to meet up with me. So the second I found out that she, again, I asked, she'd do no stipulation. She ends up saying, you have to meet up with me. And then she says down here, I said, you're willing to meet up in a very public place. You will take the test afterwards. So no, it's with a week worth of stipulations and hopefully more. So again, she stated that after she said she wants to take the test, she then confirmed.
I'm going to play this in 1.25 because I see here that K-Dub says next hearing is when Deandra shows up. Hopefully we can get to that one.
12 over the objection.
13. So again, another message from Laura, different number. I asked her if she'll meet up with the court, the mediator present. She said that's not how it goes. We can meet up just us, and I will withdraw the request for sanctions. And then again, I said, would you meet up in a public location? This thing was cut off. It was in another text message.
Is that the November one?
Disagreeing to or not being willing to meet publicly. She said we had to meet privately, and so then I blocked her on this phone number as well.
13 over the objection.
Okay. How am I doing on time?
Is that the November 2nd
That's okay.
one?
I want to skip now. I want to make sure I get to the ones that I really want to talk about.
Mhm.
Okay, so Exhibit 15. Laura sent me a very alarming message stating that
Do we know why she isn't in court for this? Well, she claimed she was very, very threatened by some things, supposed emails or something. That was never shown to the court, but that's the reason why she claimed she couldn't be in court at this point in time. Now, folks, is anything interesting happening here except Mr. Clayton doing a good job for a non-lawyer? Because then we can go directly to the November 2nd hearing. But you tell me, you know more about this case than I do.
she was going to kill herself if I do not remove it was a video that I posted to my Instagram. So Laura has claimed that my responses online were meant to defame her, but that is not the case. Laura decided to leak this story to the Sun originally, and she leaked it with her as anonymously, so she did not place her name out there. But what she did do is she mentioned to them that we had an active court case. So that active court case, she is the one that brought that against me. In that court case, her name was on the court documents. So she ended up then bringing that, figuring out once this was leaked to the Sun, they submitted the story, and then it stated that within that document that there was an active court case with me. People then searched my name and found her name through that. So this email right here, she was basically threatening me to take down my video. In my video, I just stated that this individual was making these claims. I just made a statement of the facts that they were making these claims, and they opened a court case against me. And then from there, I do have a large following. I am a public figure, a celebrity, I suppose. I don't like that word. But I have a large following, and then that audience, I cannot control what they do. But they then went and found that court case in the system and found her name, and then started to talk about her online. And then Laura, I assume, was feeling the pressure from it being online and her name being out there. She then sends me this alarming message, which again I felt was harassing, but to threaten to kill herself, I don't think anybody should ever receive a message such as that.
Yeah, I can see this KSL Pinko, that he doesn't know how to stop Laura and her lawyer once they get going, because he doesn't know the rules of objections and stuff like that. And thank you again, Jersey Jan. A little towards a wheel spinning. Yes, we are now $48 from the next spin on the wheel. Thank you. Well, the end of this is when she asked the judge to show belly. If he had adequate representation at this stage, Laura would be in prison by now. I don't know. Because if he got a ruling on this without... Because after this, after all the changes, and then having Gingrash on, because Gingrash, once he got on, that is what took this to the court where she actively lied. Without Gingrash, this would never have reached that hearing. How drunk is Nick? Not as much. Only one spin on the wheel, so I am 1 beer and 1 shot in after an hour. So that's basically gone. But thank you for your $5, bringing us to 43 to the next spin.
All right.
Your Honor, I'm going to continue to object for the same reasons that the other exhibits 2 through 11, actually 2 through 13, for the same reasons. I don't think that, again, this is showing that this is harassment by sending an email to him, asking him to take down posts, or saying that maybe she is suicidal. And for those reasons, I'm requesting that this not be admitted into evidence.
All right. I'll admit 15 over the objection.
Thank you. Come back to that.
All right. Julio, $50. Wow, thank you. Not sure where the wheel tracker is at. So cheers, Nick. This case should have more coverage to show a good female judge or two exists. Yeah, I believe the judge here makes a good balance because he is pro se, which normally is a complete clusterfuck, but he is doing it as best as he can, which makes her job easier in admitting evidence. I've seen pro se with good evidence having it not admitted because they don't know how to present it. But thank you to Julio, and thank you very, very much. That's so generous. And Josian, hit that like and sub, ring that bell, which brings us over the top and 41 to the next spin. But here we go. It is time for the Wheel of Regrets. And it's hot sauce. All right, let me find a spoon. And a hot sauce. I'm taking this one. This one has Carolina Reaper, habanero, apple, blueberries, boysenberry, onion, garlic, honey, farin sugar, and smoke. Thank you so much. Thank you so much. Thank you so much. Dun, 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 dun. I will try to not spill it all over me this time. Do you remember that? Dun 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 dun. Oh, there. Whew. Nick is so Swedish. Yeah, yeah. 100% Scandinavian. Czech family back about 800 years. Julio says, hope that helps with your trip to visit Jeff. It will. Thank you so much. Whatever gets into my accounts now is what I can replenish after I get back, because what I earn in August won't come to me until end of September when I get back. But everybody was very, very generous to me in July. So at the end of August now, I think I get around $2,000 from all the ad revenue and everything, which is great. Now, can I make a living out of it? No, not even close. But it helps me do these trips to the United States, having meetups and everything. It really, really helps. Thank you so much. Whew. Wow. All right. Back to the hearing.
That's fine here. I'll jump ahead here just to Exhibit 23. So Laura has contacted multiple nonprofits that I work for in attempts to defame me and basically get them to not work with me. So in this email here, she sent this to the Arizona SPC. This was I just spoke actually at this Hope conference. I'm a mental health advocate. And so Laura began to blackmail me and reach out to individuals that she had seen that I interacted with online. So I'd like to admit this as evidence that, again, she was harassing me through reaching out to individuals close to me in attempts to defame me.
And how did you get this? It was sent to you as well?
She copied me on email.
Okay, and when was this sent?
This was sent on August 3rd, 2023.
Okay. Any objection?
Yes, Your Honor, I'm going to object because
What happened with Jeff's dog? Jeff's dogs went first to their veterinarian, who took care of them for a number of months. And to my knowledge, they are now in the home of friends of Jeff, where they are having a good time. So, yeah, Yoda and Strawberry are doing fine. They are doing fine. And yeah, on my trip to Utah, I will visit Logan and I will visit Jeff in Logan. I will also meet up with Connor and Daniel in Utah.
this appears to be an email that Mr. Eckert was either to or CC'd on that indicates George's reasoning for why she believes that he shouldn't be a speaker at this conference. Again, this isn't harassment, and it doesn't seem like it was directed toward him. It was directed, although he was CC'd in the email.
Of course it's directed to him. She is trying to get him unemployed, and she wants him to know that she is doing this. That is harassment.
In relation to whether he should be speaking at this based on what was going on and his credibility. I don't think this would be appropriate to be admitted in this case. This wasn't directed toward him for harassment purposes, and so this shouldn't be admitted.
All right, I'm going to admit 23 over the objection.
Good choice, Your Honor.
I would like to now go to Exhibit 26. This email was sent by Laura threatening to sue me, again, with the videos that I was posting in order to protect my own image. My image is how I make my money, and I make my money online, mental health advocate. Also, being a public figure, I have brand deals and such and companies that I work with. So everything that I've stated, I've never once mentioned her name in public. And then in this email, as I put out a video to protect my own integrity and protect my own reputation, Laura threatened to sue me with a massive lawsuit and stated she had an unlimited budget to sue me, which I thought was very harassing in nature.
Is this the same video that was the previous nature of the other email that she was asking to take down? Or is that something?
I believe this one was. To be honest with you, again, I put up a few messages or videos. I believe that was referencing that video, where again, I believe it was either that, but to be honest with you, I'm not sure if it was that one or if it was the one where I stated I had scheduled a prenatal paternity test and I was waiting for her to schedule her portion. I submitted I think I put 3 or 4 public statements online, and every time she had threatened me to take it down or face legal action.
Any objection to 26?
Yes, Your Honor, same thing that I've been objecting for this entire time. Again, I don't think that this email specifically shows that she was trying to harass him. I don't think that is relevant to the petition. And for those reasons, I don't think this should be admitted.
I'll admit 26 over the objection.
Thank you.
I think this attorney right about now is realizing that Laura has not been truthful to him, because he's objecting to everything because he never knew these things existed. Julio says the next hearing was fire. So it's up to you guys if you want to move on to the next hearing, or if we should continue here.
19 now. This is again another email that I was copied on. Laura had sent this to my father. Sent a long email basically saying that I blocked her and that hopefully he could get through to me and get me to end up talking with her. So she again, I want to admit this just to show that she went to various different avenues, friends and family, in order to bring light to.
Skip to belly moment, then move on. Okay. Somebody said it was at the end of the hearing. There she is, really showing off.
In this hearing, and I don't think the court can order that my client not saying that she.
Oh, she. You see what she did there? Now she discovered she can tilt the camera to show her fake baby bump.
I'm just indicating that I don't think that this court can order her not to have any contact with him at this point. They have a family law case together. We actually have another protective order hearing tomorrow. I don't think the court has the power to do that. I don't think that that request should be granted.
Yeah, I don't know that I can do that
And
officially. I think
she's
that we can note Ms. Owens hears your request and is asking that you cease any communication between now and when we are able to redo our hearing, unless there's a need to do that, you know, specifically for the family court matter. But I'm assuming you would communicate while at a court hearing versus outside of a hearing. So let me look for another date.
she's desperately trying to show that thing off.
Your Honor, is it possible for me to show Clayton that I am in fact pregnant because he hasn't seen me?
No.
Nope. Oh, let's listen to that again. Let's play it in normal time.
Your Honor, is it possible for me to show Clayton that I am in fact pregnant because he hasn't seen me?
No.
Well, that is one judge. No. Oh, that was good. Oh, that was good. Let's listen to it again. I bet the judge has seen her doing all that theatrics, the entire hearing, sitting down to show her bitch ass face, then standing up, rubbing belly. I mean, the theatric. I mean, judges generally pay attention, even when you think they don't. And her answer tells me, oh, she noticed.
Your Honor, is it possible for me to show Clayton that I am in fact pregnant because he hasn't seen me?
No.
All right. Just the casual. No. Tiniest reaction. What she's asking me what? And then just no. Oh, the judge saw exactly what was happening. Is that Scottish flag in the emoji supposed to be a Swedish flag? No. It was. Ooh. I have a Scottish guy who has been a member forever and also does monthly via PayPal. And he asked, and I said, sure. So that's why the members only emojis has the Scottish flag. Yay. All right, let's get to February 2nd. Now, Clayton Eckert has a lawyer. Uh-oh! Somebody's gonna get their ass whooped, I guess. Oh, it's a set of lawyers. Oh, is that what's the name you gave?
Yeah, actually, let me look at the worksheet really quick. One of them isn't even one that I'm trying to. Yeah.
Okay, it would be that one.
Yeah. Did you guys not have it?
Yeah.
It would have been. I labeled it like 15.
Dandra. Okay.
USB. Do you have that USB?
I think I do. I do have it on my computer.
Okay.
So
and
we
if it's
printed
labeled,
what you gave us. I know somewhere that
if it's labeled like 1 for 15, 15 just if it's 15.
Oh, I think
that's the one then. Because ours started at 55.
Megan showed me
59
bits
would
of
have been the
this.
last one.
That would have been.
Megan showed me clips of
Okay, perfect.
the cross-examination.
Okay.
Yeah,
Yeah, no problem.
that
I
will be
actually
amazing.
planned to- yeah. I didn't know that the court was gonna lodge it like that. Like, I'm used to them doing like defense 1, plaintiff 1, like, that's what I know. They're gonna lodge it like all of them.
All at once.
Yeah.
Yeah, it's a little different.
Yeah, and then that one, that was just a mistake, and don't even worry about it. I'm not going to try and admit it.
Awesome, thank you.
All right. Thank you. You may be seated. All right. So good morning. I'm Commissioner Jones Texas. And we're here today in the matter of Clayton Ecker versus Laura Owens, CV 20230533952. We will start by having everyone.
Okay. I just asked Suno to make a song about this. I haven't heard it yet. I just gave it the prompt, and we can just see what it gave us.
Laura's got a secret, oh what a tale. She spins a wild story, sets sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. She points her finger, you're the bad guy now. But truth's got legs and it's taken a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. The justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. So kids, remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dreams. Oh Laura, Laura, what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all.
Hey, that came out good! Oh, I'm going to do try to fix a video, an intro video with this song, and to the next time we go through this. Yeah, that came out good. All right, now we can continue.
State your name, Ms. Arena, if you want to begin.
Good morning, Your Honor. Deandra Arena, counsel for the plaintiff, Clayton Eckert. I'm also accompanied by Isabel Rainey from my office, who's an associate.
You, Ms. Reference?
My name's Clayton Eckert.
Thank you. Yes.
Good morning, Your Honor. Attorney Joshua Lopez representing Laura Owens, who's present before the court on Microsoft Teams.
Right, thank you. Ms. Owens, if you can say your name for me.
Laura Owens.
All right. thank
Oh,
you.
that's
All right, so this is the continuation of the contested hearing that we previously held on October 24th. Before we start, I guess we'll discuss that there was a request to have the hearing not put on live stream. The court granted that. Then there was an objection to that filed. The court had granted it prior to the objection, but I have reviewed the objection. At this time, I'm still ordering that the live stream not be active during the hearing. The courtroom is still open. Anyone who wants to come to the courthouse can view the hearing.
We got it anyway.
In the courthouse, but I'm not having the hearing live streamed. We also
this is a recording people got out.
Notice of
Okay.
supplemental allegations filed on October 31st. Mr. Lopez, did you have an opportunity to review that?
I did have an opportunity to review it, and I'd like to object on a handful of different reasons, Your Honor. And if you'd like, I can present those now.
Sure.
So in regard to the amendment, well, in regard to the amendment, Your Honor, generally what happens in these order of protection hearings or injunction against harassment hearings, the petitioner is able to amend their petition at the beginning of the hearing before we've even started to determine what the scope of the hearing should be in regard to. In this particular instance, Clayton did not have those in his petition. And
she tried to change her name during this time? Oh, yeah. I mean, I understand why. Because, that's could be construed as an admission of guilt. Oh, I wonder if they will bring that up in the criminal case, within the felonies, as an admission to guilt. She knew she fucked up. She knew where it was headed. She tried to change her name. I would argue that in court. I would. Definitely would. Oh. Thank you so much. And that brings us to $36 to the next spin on the wheel. Thank you so much, K-Dubs. Thank you, thank you, thank you.
we are now 4/5 of the way through his petition. Not only that, we've started the hearing and he's ended his case in chief. We've already presented now. He's ended his testimony. He's ended entering his exhibits. We've moved on to the defense case in chief. And we're 4/5. Again, we're 4/5 of the way through the hearing. If this was all complete on the same day, he wouldn't get that opportunity to now amend his petition once we're already about to be at the end of the hearing.
Well, unless he actively said, I rest my part, and you actually haven't started, they can always petition. And then it will be on the judge's discretion, because something might have turned up between that date and this date. So yeah, technically this guy is right. Had this been the same day, then they already started, but they haven't. Anyway, I can turn the volume up. Hold on.
Just because he's now hired counsel doesn't give him a new opportunity to now amend the petition or add exhibits or add testimony. That would essentially be restarting this whole hearing over again, opening up the petitioner to be able to testify and then cross-examination, and then we would get a chance to respond. That wouldn't make any sense. It's too late now. He shouldn't be able to amend the petition at this point.
Yeah, Mr. If you wanted to be heard.
I do, Your Honor, and
You can remain seated. It's
Okay.
better for the microphone anyway, so.
whatever the court's preference is, of course. Your Honor, with respect to our request to amend pursuant to Rule 38D, it's our position that we are able to amend at this point in time. Mr. Eckert has already provided testimony to support these new allegations in his case in chief. I believe the purpose of Rule 38 is in part for judicial economy. As the court's well aware, Mr. Eckert could proceed with filing an additional injunction against harassment at a later date. So we're really just doing this to ensure that the court has all the necessary allegations to proceed with making a determination in this hearing today. I don't believe it's prejudicial whatsoever. Again, the testimony has already been provided to support these new allegations, and I think it's important that they be added so that the court can make a determination today, and Mr. Eckert doesn't have to come back another time with a new injunction.
All right, thank you. So when I first received it, I was concerned that we were, just adding stuff at the last second. I do think that these are just making more specific allegations that we did discuss, that Mr. Lopez did have an opportunity to cross-examine him about, because they were based on exhibits that were already admitted and have already been admitted at this time. So I will allow the amended allegations at this time over the objection. But I do have the same concerns Mr. Lopez expressed, which is we're not restarting this hearing. And so the reason we reset it was so that Mr. Lopez could ask Ms. Owens questions about their exhibits and admit whatever exhibits they were choosing to admit. Mr. Eckert, I have given him an opportunity to review those exhibits prior to those being admitted, since he hasn't had an opportunity to see those. So where we are in the case is that Ms. Owens has testified primarily. She is going to, finish her testimony through whatever exhibits Mr. Lopez wants to admit. And then Mr. Eckert would have the opportunity to cross-examine Ms. Owens, because that part he hadn't concluded yet. And then we would do closing arguments. So that's kind of where we are. Okay.
Just a question, Your Honor. So I understand that you're going to allow the amended petition, but as far as the exhibits that the petitioner was trying to supplement, those are not being included. Is that correct? He's not getting the opportunity to admit additional exhibits. Is that correct?
I mean, I guess the only thing I have about the exhibits, and I haven't seen that, I haven't reviewed all of those exhibits. The only thing I don't know about any of the exhibits is if they were in response to any of the exhibits that you have, I guess is what I'm not.
I guess I'm not sure either.
I guess that's the only thing I don't know, but at this point, I do think his, case has been basically concluded.
Okay. My final question is, as far as this hearing, I know it indicates in the minute entry, it was, we were just going to go for 30 minutes. Is that 30 minutes altogether? Is that 30 minutes for us to present our exhibits? Is that broken down? I just want to make sure that I'm efficient with my time as best I can be.
I mean, ideally, we're here for 30 minutes, but I will extend it to 45 minutes to allow everyone to do closing. So the test.
I can see here already on the 126, it took longer than 45 minutes. Oh, this is a good statement. Laura's parents seem to be a huge part of the problem. I know she allegedly a grown-up, but if my adult child were out here doing this, I'd get her some help. I think she is extremely spoiled. Never been told no. Been told every guy will want you, they only need some persuasion. They do mean things because they like you. You deserve anything. Was that energy drink? Hold on. Let me go back and look.
Question is, as far as this hearing, I know it indicates in the minute entry, it was, we were just going to go for 30 minutes. Is that 30 minutes altogether? Is that 30 minutes for us to present our exhibits? Is that broken down? I just want to make sure that I'm efficient with my time as best I can be.
I mean, ideally, we're here for 30 minutes, but I will extend it to 45 minutes to allow everyone.
Yep, that is her claiming to be 6 months pregnant in a high-risk pregnancy. gulping down a monster. I could tell you guys with absolute certainty, her doctor, if she actually had one, would have absolutely banned her from having those. Absolutely would have banned her. I need to take a screenshot of that. Hold on.
As best I can be.
I mean, ideally, we're here
No.
for 30 minutes.
Hold on. I need to remove that one.
But I will extend it to 45 minutes to allow everyone to do closing.
Oh,
The
that's a good
testimony portion,
screenshot.
And that would include cross-examination time would be the 30 minutes.
Okay, is it like 20 or is this like 15 and 15? I just want to
Yeah,
make
20 is fine, and then 15, 10 minutes to cross-examine if we need to, and 15 minutes for closing, sort of around that
Okay.
time.
All right, thank you. Your Honor.
Okay, Ms. Rena?
Your Honor, with respect to the exhibits, the supplementals, they are, for the most part, impeachment exhibits with respect to Ms. Owens' prior testimony. So that's what they would be using for. And so I guess to answer the court's question, they are responsive to defendant's exhibits here. So it would be utilized for cross-examination. That's what the supplemental exhibits are for.
And I mean, I think you could use them for impeachment purposes if you felt they would be relevant. So I just don't know if she has them to look at to.
They were disclosed to Mr. Lopez on, I believe, yesterday morning.
I was able to send them to my client, Your Honor.
Okay, thank you.
And Your Honor, one last thing. While I understand and respect the court's decision regarding the courtroom being closed for live stream, I do have concerns regarding the fact that Ms. Owens is present virtually and who's present, in her household and who else is being able to listen to this. My client, unfortunately, with this hearing not being able to be live streamed, is being precluded from having any of his family, friends, or any other persons that may want to listen in support of him from being able to do that. So I would just ask that the court at least confirm with Ms. Owens that no one is present. I know this is hard to confirm, but that's one of our concerns.
Okay, I'm not sure. I mean, obviously his family can be here, and I'm not sure he looks like he has some people here, but Ms. Owens, is anyone else with you?
No, I'm in a casita by myself.
Okay.
I can also pan if they want to see that nobody else is present, if that would be helpful.
Okay. All right, thank
Uh-huh.
you. All right, so Mr. Lopez, you may proceed.
Yes, Your Honor. I want to turn the court's attention to, and I'll jump around here a little bit, but Exhibit 38. And Your Honor, do you have that available? It's a video. Do you need a USB?
You can hook up to your computer, sir, to show it. I can make you a presenter.
I can play it on my computer. Is that what you? Because I can bring it up there.
Yeah, if you want to present it, then I can make you a presenter, and you can. Well, actually, because I think you need the little hookup thing to that.
Yeah, there were some technical difficulties. I want to either say last time or in a different court. I could try and do that. I don't have the.
I don't know, Beth, if you can bring in those hookup things.
What was that, Your Honor?
I'm trying to get my JA to bring in the little extra extension thing that I think you need. And I think they just hook up to the thing, and then you can hook them up to your computer. But then I think they need to hook up to that.
I don't have like another cord that needs to be plugged in.
I'm not 100%, but it's supposed to, I think there's a cord already there, maybe.
I was the one for this.
I'm gonna try to see your A or B, but
Hi, Derek. Good to have you here.
If that doesn't work, then the other thing I can do is just plug it directly into my computer. Is it working?
I mean, I need you a presenter, but I don't see anything currently. I just see you.
Let's just say her having a monster is more bad for her than my last Friday getting blitzed. So no, there's no way. Oh, thank you, K-Dubs. Nick, if you have time for a deep dive, her horrible equestrian videos during this time are great. Yeah, I've seen them. I know where they are, or at least where one is. And once we get through this, I think we should end off this stream with her equestrianism. I have at least one clip.
Right now, but I don't know if you want to try to.
Okay, let me just try one more thing.
Then thank you. That gets us to $31 to the next spin on the wheel. Thank you. Thank you, thank you, thank you.
How about now, Yana?
For you who wonder, what spin? What spin? This is the Wheel of Regrets. Every $50 in supers, gifted memberships, buy me a coffee or PayPal, I will spin the Wheel of Regrets, and you will see me suffer on hot sauce or having a shot of something. That's today's entertainment. Your goal is to have me fall asleep. Again.
Are you playing something? Or?
Not yet, but I wasn't sure if it would just show. Now I'm playing something.
Not seeing anything. I still just see you.
Would it be okay if I just brought my computer up?
Sure, as long as everyone can.
Okay.
So you know, to come up and see it too.
Okay. Lloyd, do you have in front of you exhibit that's marked 38?
I believe I know the one that you're referring to. I don't have it in front of me, but I believe it's the video of my pregnant stomach. Is that correct?
Yeah. Is this an accurate video of you?
So it's actually not showing up at all on mine. Your Honor, I can see you and I can see Mr. Eckerd's counsel, but I can't see my attorney or anything else.
You can't see me?
No,
If you can maybe just put it near the, we might be able to see it just on the screen there.
She's saying she can't see all the participants.
She can see you. Well, can you see him now?
I cannot. I can only see you and I can see Mr. Eckerd's counsel.
I mean, I can maybe unmake you a presenter because I think maybe that's what happened is. Can you see him now?
I cannot.
Can you click something on your screen, like participants? Or a different view?
Let me see.
Okay, gallery, whatever.
If I wanted
no, nothing else.
If I wanted Vegemite to this Wheel of Regrets, I would add, because we can buy it over here. I'm not having Vegemite on my Wheel of Regrets. I'd rather have rotten surströmming on my Wheel of Regrets than Vegemite.
Nobody else is showing up.
Thank you for the suggestion, Wednesday.
Exhibit 38.
The video of my pregnant stomach.
Yes. What is it?
It's a video that I took of my pregnant stomach because Mr. Eckerd asked me to take it for.
Oh, we get to see her lactose intolerant, gluten intolerant belly. Folks, for you who don't know, I have 4 sisters who, one or the other, has been pregnant the past 22 years. I have cousins to add on to that. I've seen what she shows, and that is a gluten belly, not a pregnant belly. So, which means, in my personal opinion, because we now know she was never pregnant, we now know she even claimed that she had a miscarriage in July, months before this, that she wasn't pregnant. So not even by her own words can she be pregnant. So we can easily conclude that it was either doctored or a gluten belly. And thank you, Leanders. €5. €5. Thank you so much. Oh, we are getting closer. We are getting closer. $26 to the next spin. Let me check my mail and see if anything else. Nope, no. Not anything via PayPal. Burrito belly.
For him to verify that I was indeed pregnant.
Cheers.
Okay. And is this video an accurate reflection of what you look like recently?
And thank you.
In September, I believe.
And is this a video that Mr. Eckerd asked you to send to him?
Yes, it is.
Was that to show proof that you were in fact pregnant?
Yes.
Your Honor, I'd like to move into evidence exhibit 38.
Your Honor, objection. I don't believe sufficient foundation was laid. Also, the
Yeah, and by the way, that's twin belly is something special. It doesn't look, yeah, yeah. And by the way, it's really unnecessary because by now we know that she was never pregnant. Yeah, yeah. This is the time where she was chugging energy drinks. We got one about 10 minutes ago, and I guess we will get more.
video does not have any time or date stamp on it to be inherently reliable.
I mean, I can't see it, but
Is there any way, Your Honor, for the video to be played on the Microsoft Teams?
well, that's what I think we were trying to have them do with that. The hookup thing, but I don't know specifically how to do it. Beth, do you know how to hook it up or no?
I do not, but I can ask next door.
Let me try to make you a presenter again.
Your Honor, I hit play a couple times. There's nothing's happening.
Okay.
Wouldn't take it away.
All right, do you just want to lay a little more foundation for the exhibit itself?
Yeah, so, Ms. Eckert, when did you say that you took this video?
I took this video in September, and when I did send it to Mr. Eckert on that date via email, I also sent him a screenshot that showed, like if you scroll up on a video, and it can show exactly when it was taken, where it was taken, to prove that it wasn't something like I had edited or taken prior to that.
And why did you take that video?
I took that video because he had asked me for a video to show him that I was pregnant.
Okay, and
Yeah, I'm sorry.
the video that you submitted and that we're requesting the court enter into evidence, this is the video that you're talking about?
Yes, it is. I was able to pull up 38. Yes, that's the video. And
Your
I did
Honor,
it.
at this time, we're requesting that this be entered into evidence.
Again, I reiterate my objection, Your Honor. I don't believe sufficient foundation has been laid. She said September. I don't have the date in September of the year. There's no proof she sent this to Mr. Eckert, and furthermore, we don't have proof that it hasn't been edited.
Your Honor, she's testified that this was the video, that she sent it in September. She sent it because Mr. Eckert had indicated she should send it to him to show that she was pregnant. The foundation's laid. She testified to all of this.
So does the video that you're looking at in Exhibit 38, is that a true and accurate depiction of the video that you made in September?
Yes, it is.
All right. I'll look at the exhibit over the objection.
Was it working?
38. Okay.
Okay.
Ms. Owens, I'd like to take your attention to Exhibit 40. Can you please explain what these are?
These are text messages that Clayton sent me from the time when he found out that I was pregnant through, I believe it was the beginning of July. And these were text messages, for example, that showed that I believe it was the second to last one, shows, "I'm sorry, this made it harder. I wanted you to come over to confirm what I was doubting," and it did confirm that. So I don't see you as a liar anymore, proving that I had gone over to his house and taken a pregnancy test that he had purchased in front of him and that he knew I was
Your Honor,
pregnant.
I'm going to object at this time. She's reading exhibits that have not been admitted into evidence. More foundation needs to be laid, as far as I'm concerned.
Your Honor, I think that she's just trying to explain what these are, and she is.
Well, I mean, if you can explain that without reading the whole exhibit. So.
Okay. Okay, but that, are these text messages that Clayton had sent to you?
Yes, they are.
Is the phone number that is indicated at the top of each one of these text messages a number that you know to be Clayton?
Yes, it is.
Okay. Was that a phone number that Clayton had texted you from previously?
Yes.
Do you know if Clayton had changed his number since he had texted you from that number previously?
No, he had not, to my knowledge.
Okay. And these text messages, were they sent to you during the time periods between when you became pregnant to when this petition against you for this injunction against harassment was filed?
Yes.
Are these accurate reflections of those text messages? Have they been altered in any way?
They have not been altered in any way.
Okay. Your Honor, I'd like to admit into evidence Exhibit 40.
Any objection? Sir, I'm objecting for the record. I think there's a completeness issue here. These text messages have been altered. As the court can see, these text messages only include the statements that Ms. Owens wants to include here, not the context surrounding the text messages. I also believe that there hasn't been sufficient foundation laid with respect to the actual dates that these text messages span.
All right, I'll admit 40 over objection.
All right, I'd like to turn your attention now to Exhibit 47. Do you have Exhibit 47 in front of you?
Yes, I do.
And what is this exhibit?
This is an email I got from Clayton on September 17th saying that he was unbothered by me going to the media about the situation.
Okay, now, you said when was this email sent to you?
September 17th.
And it was your understanding that it was sent from Mr. Eckerd?
Yes, correct.
Okay, and what was this email in response to?
This was in response to me saying that I had told him that if he didn't continue to participate in the paternity case, that I felt like I was going to need to go to the press because I thought that would pressure him to come up with a parenting
Objection,
plan.
Your Honor.
Yeah, Miss Owens, you kind of forgot one thing there. The stipulation: date me, date me. Laura Owens, you are undateable. Completely, especially now. I mean, you're not getting any younger, and you have a history of trying to scam men to date you, which to me tells me you already knew you were undateable, so you had to try to force guys to date you. So tough luck.
She's providing a narrative that's not part of this exhibit. Again, this is a completeness issue here. She is cutting out the portion she wants and leaving out the context, which would be the email that she sent him that he's responding to.
I'm only.
If you want to present the other half of it, obviously you can. I would go ahead and admit exhibit. What are we, 40?
Okay, Your Honor, yeah, at this time I'd like to admit this exhibit.
47. That'll be admitted.
Okay, I'd like to turn your attention to Exhibit 37. This again is, what is it?
I do not have Exhibit 37 in front of me.
It should be a video.
Can you possibly give me the context for which video it is? Or
It should be a video that was posted by Clayton.
oh, okay, yes, I know exactly the video. It was a video that Clayton posted on October the 6th on his public.
Wait, what is it? What is this video?
This is Mr. Eckerd telling his 200 and nearly 300,000 followers that the results of our paternity testing were back and he was not the father, when in fact the paternity test results were not back.
Okay, so you had done a paternity test?
Correct.
The results are not back?
The results are still not back. The testing is ongoing according to the lab.
But since
Oh, that is a lie. We know that now. She lied. She never submitted a test to. No, she did submit. At least it is a test that came back 0 to none fetal tissue. I mean, it's hard to keep track of all the shit she's lying about. You tell me, guys. You know more than me about this case. I'm just here having fun and trying to make me drink.
Since the paternity test had come back, you are indicating Clayton had posted a video?
Correct.
Where was that video posted?
I'm sorry, did you say where or when?
Where?
It was posted to his public Instagram.
When was it posted?
October the 6th.
Okay, how did you get a copy of it?
I got a copy because it was on his public Instagram.
Okay. And was this an accurate report? Have you altered the video in any way?
No, I have not.
Okay. Your Honor, I'd like to admit Exhibit 37 into evidence.
Sir, I'm objecting on relevance. This case is about Ms. Owens' harassment of Mr. Eckert. Mr. Eckert posting anything on his private social media is not relevant to this case.
Your Honor, as part of the petition that Mr. Eckert had written, he had indicated that my client was defaming him when in fact my client was not defaming him and that she was harassing him by sending him emails and different text messages. I think that this is relevant to show that not only were the text messages and emails concerning my client's pregnancy, paternity, but also what I had indicated in my opening and evidence that we had Ms. Owens testify to, that she did in fact also message Clayton to take down certain false videos or false statements offline because she was getting harassed by his fans and followers. So this video is to show that this was the video that he had posted, and the reason she had continued communication with him beyond just the pregnancy and paternity was for him to take down certain videos, that it wasn't for harassment and that it was for legitimate purposes. This is that video that we want to present to show why my client was communicating with Clayton regarding that specific issue.
All right, I'll admit the exhibit for the purpose of that limited purpose that you're referring to.
Confirmation to publish to the court.
Okay.
It's Friday, and you know what we need on a Friday? We need some good news. Who's got the good news today? I got the good news. What's that good news, Clayton? Well, test results came back early, and they said little to no equal DNA present. Let's go, baby. We knew, I knew that was happening.
Yes, there it was. That first test had come back, and as where is it? Where is it? It was right here. There it is, from Online Red. Little to no, and she insisted on another test. That got lost, hence ongoing. Oh yeah. So he was not lying. And thank you to Patty for being a member for 7 months. Love this channel. Lovely. Loves you too. Loves you too. Thank you for being a continuous member of this channel. And when we are talking about that, hold on. Let me see. Yeah. YouTube allows me to gift 10 free memberships each month. Yesterday, I gifted 5. And today, I'm gifting 5 more. That does not go to the spin on the wheel. And it got to Julio, Virginia Farizo, Sloothy Goosey, Motion to Scream, What the F, Granted, and Eponineske. Congratulations, you 5. You now have access to all my members-only content. You will have early access to all videos I publish. And you damn, I still haven't got myself to a fresh link to Discord. Yes, I have a Discord page. And you also have members-only emojis here on YouTube. Yeah, translation. Laura didn't get the results she wanted. Yeah, I mean, she can fake some tests by eating supplements, but she cannot fake fetal tissue.
I finally put to rest. Thank you all to those that supported me and waited until everything came out and spent false accusations in 2 years. I really don't want to, look ahead to next year and see what's going to happen. I think false accusations in a lifetime are enough. So thank you all for the support, love, trying time that I learned so much about myself. And now back to the regularly scheduled programming. Hey, listen, it's Friday.
About 5 more minutes.
All right, I'd like to turn the court and Ms. Owens, I'd like to turn your attention to Exhibit 44. What is Exhibit 44?
Exhibit 44 is a text message I received from Clayton on June the 4th.
Okay. And was this, okay, this was from, is this a text message or is this an email?
This is a text message.
Is this an accurate reflection of the text message? Has it been altered in any way that Clayton had sent to you?
No, it has not been altered, and yes, it is accurate.
I don't see a phone number in here. Was Mr. Eckerd's phone number saved as Clayton Eckerd in your phone?
Yes, it was at that point.
Okay.
That's not what he asked you. He said, I don't see a phone number or Clayton saved in your phone. He was saved on my phone. No, but that's not his statement. On this supposed text message, you don't see his name or phone number.
And I'd like to admit Exhibit 44 into evidence at this time.
Any objection to 44?
Your Honor, I would just object for the record as to completeness. Again, I believe there is more to this text message than what is being disclosed in this exhibit.
All right, I'll admit it over objection.
Okay, I'd like to turn to Exhibit 46. Ms. Owens, what is Exhibit 46?
Exhibit 46 is a variety of different medical providers that I saw confirming that I am in fact pregnant from the day I found out I was pregnant on June 1st through, I believe it was last week. It may have been through the week prior to that, but I have the dates on there through October.
Okay.
11th. Yeah, I'm sorry.
Okay. Were these pictures, why were these pictures taken? Why did you save these documents?
I saved these documents again to try to prove to Mr. Eckerd that I was indeed pregnant because he doubted me. Yes, he did.
To show why?
He asked for these documents to show that I was indeed pregnant and that the pregnancy was ongoing and that it was viable.
Have you altered any of these documents in any way to misconstrue their meaning?
No, I have not altered them.
And are these an accurate reflection of these documents?
Yes, it's entirely accurate.
They are your documents?
Yes, they are.
All right, Your Honor, I'd like to admit Exhibit 46 into evidence.
Your Honor, I'm not objecting because I believe the court needs to see these exhibits, but I will note that we have concerns regarding what they're being offered for.
So I'll admit 46.
That should make you worried, Miss Owens, because when you submit evidence in court, you really don't want opposing counsel to say, thank you, we really, really wanted these ones entered. Yeah, my pregnancy is ongoing, and then a few months later, oh no, she had a miscarriage 3 months prior. Because all of a sudden, Grayskull, Gangrel, whatever his name is, realized that after 6 months, you have to submit to the state, because then it's no longer a miscarriage, it's a stillbirth, meaning you need a grave and all of that.
I'd like to take your attention to Exhibit 48. Do you have that in front of you?
I do, yes.
Okay,
Raising the volume.
This is a letter from the Arizona Department of Real Estate that they sent me after looking into Mr. Eckerd's conduct when he was my realtor, showing that he was found in violation of professional conduct for not submitting an offer.
Okay, was this something that you received from the Arizona Department of Real Estate?
Correct.
Did you alter this document in any way?
No, I did not.
Did you receive it on or about September 15th, 2023?
Correct.
Okay, Your Honor, I'd like to admit this into evidence.
I'm objecting for the record based on relevance. Again, this matter is about Ms. Owens' harassment of Mr. Eckerd. I do not believe that this is relevant.
I agree. It will not be admitted. 48,
You know how much time?
1 minute.
I'd like to turn to Exhibit 50, Your Honor. This will be the final one today. Or Exhibit 50, do you recognize that exhibit?
Yes, I do.
Okay, and what is it of?
This is something that was posted to Reddit by Mr. Eckerd under a false name, and that was also in the order of protection hearing I had against him last week. It was discussed.
Okay, and did you change this image in any way?
No, I definitely did not.
How'd you get a copy of this image?
It was on Reddit. Somebody had created it, but I know it was Mr. Eckerd because only he had this image.
Okay.
Objection. She's testifying, Your Honor, regarding information that she cannot testify about. Speculating.
You can have her lay foundation that she has knowledge of.
Okay. It's your understanding that Mr. Eckerd posted this picture?
Yes, because only he had the photo and the sonogram I'm holding that's been edited. I mean,
Okay.
that's been edited.
Your Honor, I'd like to admit Exhibit
50.
50 at this time.
Was that correct? That he was the only one who had it, or didn't she send it out? You guys know more about this than I do. When was this? This is from the November 2nd, 2023 hearing. K-Dub says no. I'm trying to remember the question I asked. No, she sent the Dropbox links to Dave, Neil, and Steve. Yeah, thank you. Yeah, so Clayton was not the only one because she sent it out via Dropbox. Huh.
I'm objecting. This is inherently unreliable. She's failed to lay sufficient foundation. This was not posted by Mr. Eckerd, and she provided zero proof that this was posted by Mr. Eckerd or further that this was sent to Mr. Eckerd in this manner.
I'm going to sustain the objection and not admit 50.
Okay, nothing further this time around.
Examination.
Before
He didn't even try to argue.
Requested these, the court's willing to entertain this, that we be permitted to go until noon. And I would be willing to waive closing argument because I do have important questions that I would like to go through as opposed to presenting the court with a closing argument if the court would allow that.
Let's see how we're doing on time.
Oh, Miss Owens. Now when an attorney voluntarily says, I will waive closing arguments because I have a lot of questions. Miss Owens needs to put on an adult diaper because you are about to shit yourself.
Thank you, Your Honor. Good morning, Ms. Owens.
Good morning.
You were thoroughly questioned by your attorney at the last hearing in this case on October 24th of 2023, correct?
Correct.
And you understand that you were under oath at that time and you remain under oath today, right?
Correct.
And you're aware that any false testimony that you provided or provide today could be considered perjury, right?
Yeah, absolutely.
And so based on that, Ms. Owens, before I proceed with my line of questioning, do you have any prior testimony that you'd like to correct at this time?
I do not.
Oh, she laid that trap.
I want to make sure that you're clear-headed. And obviously, it's your position that you are pregnant with alleged twins, correct?
100%. Yes, correct.
What medications are you currently on?
Objection, Your Honor. Relevant, and that's an inappropriate question for this.
Overall, it can be impacting your testimony.
I'm on prescribed prenatals and I'm on folic acid.
Prenatals?
And I also take lamotrigine for epilepsy.
Is there
Prenatal together with... Well, I'm not that versed in what goes together and what not goes together. But all of that medication together with energy drinks that she's been gulping down. Yeah. this is what this is why Clayton should have had an attorney to begin with. Have that as a lesson. But on the other side, since he didn't have an attorney until now, Laura buried herself. And now she has 7 felonies against her.
Or anything else? Is that your entire list of medications?
That's my entire list because I was taken off of anything else that I was on when I found out that I was pregnant.
And have you been diagnosed with any other medical or mental health issues?
Objection, Your Honor. I don't think that that's going into your mental health, going into your physical health, mental health. I don't think that's appropriate for this type of hearing.
That doesn't involve another question.
Depression.
Okay, and any other physical health diagnoses?
Epilepsy.
And who provided those diagnoses?
All right, I think we're now over the report of that assessment.
Understood, Your Honor. I'll move on, please. And how far along are you as we sit here today with respect to the pregnancy?
I am 24 weeks along.
And when was your last menstrual period in order to calculate your due date?
Objection, Your Honor. I don't think that that's appropriate at this time. It seems like these questions are meant to harass my client.
That's not harassment. That is to accurately calculate, because now in some countries they are calculating the pregnancy from the last period. Other countries calculate from I believe 10 days after. Now, I'm not an expert, but I do believe that is correct.
Indicated she's pregnant. She's indicated it's been about a month. You don't need to know things about her menstrual period.
I'm going to sustain the objection.
I'm
Can
sorry.
you please-
I'm sorry.
Can you please provide us with your alleged due date?
February 14th.
Oh,
You testified that there's absolutely no possibility at all that your alleged twins are anyone other than Clayton, correct?
There's no chance they're anybody else's.
But you understand that Clayton has been very clear from day one that he did not have sexual intercourse with you, right?
Clayton was not. If you look at the June 4th message,
Ma'am, these are yes or no questions. Do you understand that Clayton was very clear from day one that it's his position he did not have sexual intercourse with you?
Then the answer is no.
And as we sit here today, you have participated in 3 DNA tests to try to prove that Clayton's the father, correct?
Correct.
And not a single DNA test has come back
Oh, I'm sorry.
stating Clayton's the father.
Sorry, it was 2 DNA tests, not 3.
Well, you indicated at the last hearing that you were providing a sample for the 3rd DNA test to be completed, correct?
But the second one got there was an issue with the transit according to the lab. So I mean that wasn't tested. So I can't say that I've had 3 tests that have come back with different results because only 2 were tested.
Ms. Owens, you've provided a sample on 3 separate occasions for DNA tests, correct?
Correct, but the second was
Ma'am, these are yes or
I
no
had nothing to
questions.
do about.
I'm not looking for you to elaborate. So we'll move on. As we sit here today, not a single DNA test has come back indicating that Clayton's the father, correct?
The samples were diluted and I'm going back next month is what I was.
These are yes or no questions. It's a very simple question. As we sit here today, you have no DNA test that indicates that Clayton is the father, right?
The results, the testing is ongoing is what I was told, as was Clayton.
So
So
you
that's not
said that on a couple occasions, that the testing is ongoing.
correct.
So is it your testimony that you provide these samples and that there's no results that are coming from these samples you're providing?
I'm unclear on what you're trying to ask me because they said that
Okay,
I need to
well-
go back next month to give another sample that the testing is not back. So I'm unclear, I guess I'm trying to say.
Isn't it true that the test came back and indicated there was 0 fetal DNA?
That's absolutely not true.
Okay. And again, Ms. Owens, you have provided no testimony, no objective evidence or documentation to date to support that you have a positive DNA test proving Clayton's the father of your alleged twins, right?
The testing is ongoing. I'm unclear I guess is what you're trying to ask me.
Who is your OBGYN?
Dr. McCool
Email her again.
and Dr. Higley.
I wasn't able to hear that, and I'm not sure if that's.
I withdraw the objection.
Can you please repeat that, Ms. Owens? Who is your OBGYN?
My main OBGYN is the perinatologist, Dr. McCool.
Really?
And what is the last time? Oh, well, you said your main OBGYN. Who else are you seeing? What other pregnancy-related doctors are you seeing?
Dr. Higley, who I saw last Friday. And
And that turned out to be not true, if I remember correctly. She made an appointment and then canceled it.
an epilepsy doctor as well. Ford, he specializes in pregnancy.
Wait,
Okay.
what?
And
An epilepsy doctor who also, yeah, I mean, it's possible. But, I mean, usually you have one epilepsy doctor who then cooperates with whatever doctor she has, the high-risk pregnancy doctor. And, yeah, as equality, she never saw. Maybe she saw her epilepsy, if she has epilepsy. But other than that, none.
in your exhibit, I believe it was 44, you indicated, actually, let me go back here. I apologize. It was your exhibit 43. You indicated that all of exhibit 43 contains copies of your medical records that would support this alleged pregnancy, correct?
I believe it was exhibit 46 that was a proof of pregnancy. We didn't do exhibit 43.
I apologize, exhibit 46, my mistake. And in that exhibit 46, all that you have from Dr. McCool here is a screenshot of an upcoming appointment for Monday, July 24th of 2023, right?
Correct, because that he's a doctor.
You understand that anyone can go online at AMOMI, where Dr. McCool works, and make an appointment for an OBGYN appointment with Dr. McCool, correct?
That is not true. Dr. McCool is a perinatologist.
Owens.
A referral to see him because I have epilepsy. He's a high risk specialist. You can't go and make an appointment with him. I had to send records to get an appointment with him.
Okay, but the only record that you provided this court with regarding your alleged high risk perinatologist is a screenshot of an appointment for Monday, July 24th of 2023, right?
No, I provided the last page was October the 11th with the diagnosis epilepsy during pregnancy from my neurologist after an appointment that day.
Ms. Owens, there is no copy of any medical record from October 11th.
Yes, there is a last page.
minutes.
It's October 11th. If you look at the last page, Zeman Glennis on October 11th, 10:53:20 Mountain Standard Time.
I apologize. What was it that the court indicated?
A few more minutes, so we need to probably step it up a little bit if you want to get to other things.
As we sit here today, Ms. Owens, you have refused to sign any sort of HIPAA release so that Mr. Eckerd could obtain directly from your medical providers evidence to support any alleged pregnancy.
No, on Friday, I literally had the doctor send it to him directly. I had my provider send it to him directly. And that's an email I sent to him telling him that it was sent directly to my son.
That's not what she asked. This is court, Miss Owens. They will have you make claims. Your opposing party has to verify them. You do that by signing a HIPAA release. And we know she never did.
The HIPAA release.
Ms. Owens, this is not the first time that you've made allegations that you're pregnant with twins within the last 2 years, correct?
That is incorrect.
Okay. So I would ask the court to take judicial notice, Your Honor, of the civil matter.
What did I tell you about an hour ago? With a lawyer there, Clayton could have asked, because he tried to get in some documents that he wasn't allowed to. A lawyer would have asked the court to take judicial notice. And here she is, asking the court to take judicial notice.
Involving Mr. Greg Gillespie, who is present in the courtroom today. And it's CV, let me get that number for the court.
I have a protected
2021.
Gillespie and against Mr. Eckert, and I wish I was aware that Mr.
You're not in the courtroom, bitch! And he is allowed to be there if you're not there. In the courtroom, if you're not there, he can be.
Gillespie
052893.
No, I'm going to object to that.
But, I mean, we had an exhibit that we discussed last time regarding that case, and what was presented was a complaint and a motion to dismiss, and there wasn't any findings from any court on anything related to that. So I'm not going to consider that at this point.
Your Honor, I do have some questions that I think are very important for the court to hear regarding that case. I understand if the court doesn't want to take judicial notice, but I do have questions that are important that I would like to proceed with regarding the uncanny similarities.
I don't think that would be appropriate for this specific hearing. We know the scope of this particular hearing. Bringing up things in
The reason why she doesn't do it is because in the last hearing we listened to, he didn't ask for it. So she already ruled on it. And she won't take back that ruling.
a separate case. There's separate issues. These are not the same thing. This is an injunction against harassment. I don't even know what that case is. It's not an injunction against harassment. I know that. It's not appropriate.
Your Honor, this goes to the heart of why Mr. Eckert needs this injunction against harassment, and Miss Owens' pattern, her modus operandi, her pattern of behavior, her pattern of making the same claims against other men in the state of Arizona within the last 2 years. And I think it's highly relevant to this case because it supports why Mr. Eckert needs this injunction against harassment, because this individual has done this before, and there are concerns that she will not stop.
I'm going to sustain the objection. I'm not going to allow that. That's fine.
And she gulps down more energy drinks while she's claiming to be a high-risk epilepsy twin pregnant. And I'm quite sure the judge notices this.
And Your Honor, I would ask, again, the court to reconsider here, because this matter, it's very important that the court hears how Ms. Owens has made the exact same allegations in another matter within the last 2 years. And that she has committed perjury in the last hearing because she made false statements under oath regarding the nature of that case. She opens the door.
Folks, I remember this from my stream with Megan Fox. Laura Owens probably has some theater training because she doesn't know how to do subtle moves. She does all of that. Those are called theater moves because it is supposed to have a theater audience see it, and through a theater audience needs the big movements. Here she is on screen at court. That is why I believe that these are complete theater. Well, we know it's complete theater, but I said this with my stream with Megan Fox. Yeah, this is theater. And my example is, have you ever seen theater makeup? At stage, it looks amazing. It's like, or a ballet or something of the sort, a theater. Up close, it's absolutely horrible because it's so exaggerated. And this is why she's using theater moves. She's using the big moves because that's all she can do. Pretend.
In her testimony, when Mr. Lopez was when he was direct examining her regarding the fact that there are no other cases that are similar, regarding things that happened in that case. So she did open the door based on her direct examination.
These are very serious allegations that the petitioner's attorney is now alleging against my client. She is insisting that my client has now committed perjury. My client has no criminal history and is not being charged with perjury. So I don't know, like, that's just an allegation. Again, these cases are completely different. we're hearing that the attorney testified that these are the same. These are not the same matters. These questions and this cross-examination of my client regarding these issues, again, would be inappropriate and is outside the scope of this hearing. In fact, it even sounds like she's trying to bring out character evidence, which would be inadmissible in a hearing like this.
I'm going to sustain the objection again. So if there's other things you want to ask about her testimony, you have about 2 more minutes.
Ms. Owens, you understand, and you testified under oath, that Mr. Eckert blocked you from communicating with him, correct?
He would block and unblock. But not from communication. It was on a text number, but we were always in email communication as recently as the day before I went to the press. He sent me an email. So,
well, Mr. Eckert told you he didn't want you contacting him anymore and then would block your telephone number, correct?
but told me to email him.
Ms. Owens, these are yes or no questions. Isn't it true that Mr. Eckert indicated he did not want you contacting him anymore and then would block your telephone number?
Actually, that's incorrect. From the early resolution conference that we had, Mr. Eckert told me specifically to contact him via text. I've forgotten that. If you look at the transcript from that hearing, you would see that. And I haven't contacted him via text after he told me to.
Okay, can you take a look at Exhibit 55 for me, please?
I don't have an Exhibit 55.
These are our supplemental exhibits.
That
would have been the ones that are their exhibits that they would have sent you.
Yeah, Josh.
Marked by number.
Josh is basically on his way out by now. Because, I mean, he's doing a great job for her at this moment, as he should. As I understand it, not a large number of days after this hearing, he did an off I fuck motion, and off he fucked.
I guess the issue hers may not be marked by number.
They are, Your Honor.
Let me check my email. I did not see his exhibits. Excuse me. Let me.
And Your Honor, I'm asking for more time because her not being prepared, knowing I presented these exhibits to her attorney yesterday, is coming into my time, and I have still several questions I'd like to ask.
I was not aware that he was getting more exhibits added after he already had testified, so I apologize. There's text messages between the parties dated 5/23/20, 5/25/23. That's all I have. I don't have the actual exhibit.
That's the first one. And then there is another one after that. Do you see?
You have the exhibit that's from May 25th?
I don't see anything. I literally just am seeing a list of plaintiff's trial exhibits 55 through 63. Can you explain what the context is for me to understand?
Are you able to scroll down?
Your Honor, I'm concerned if she doesn't have these exhibits, that we're going to need more time, because this is very important that I get through this testimony, and I provided these to counsel in advance to avoid this exact issue. And had Ms. Owens been present, this wouldn't have been an issue at all.
Right, but I have a protective against Mr. Eckert.
All right, just can you find the exhibits or not?
Let me just try to see if I can scroll down. Hang on, maybe if I make my screen smaller. I see. Oh, yes, I do. Hang on, I think I see them. I see exhibit 55. Yes, I do.
Go ahead.
Ms. Owens, do you see exhibit 55 is a text message communication between you and Clayton dated May 25th of 2023, correct?
Correct, the day after he didn't file the,
I would move to admit these exhibits, Your Honor. This exhibit.
But it's not testimony. She's asking if you recognize the exhibit. Any objection to 55?
I don't remember sending
I'll admit 55.
And here, Ms. Owens, on May 25th of 2023, Clayton says to you, "I'm debating filing a police report. Please leave me alone," correct?
The context needs to be stated. He did not make
Ms. Owens, I am
$1.1
asking you yes or no questions.
And he was found in
Your
violation.
attorney will have the time to ask you a question again, Ms. Owens. So just answer her question, and your attorney will have an opportunity to question you again.
Okay, then can you? I'm sorry. Can you repeat the question? I'm sorry. This is ridiculous.
I'm concerned that she's doing this intentionally to eat it.
All right, let's just ask the questions. You're wasting more time saying all that stuff.
Ms. Owens, isn't it true that on this text message dated May 25th of 2023, Clayton responded to you and said, I'm debating filing a police report. Please leave me alone, correct?
That's what the text message says. I don't have that, but sure.
And
that's what
right below that, you sent him another text message, correct?
that's what it shows, correct?
Okay, can we move to Exhibit 56? It should be the next page of the document, please.
Your Honor, how are we on time? Because I know you said 3 minutes. I
We're
understand.
close on time, so I want to leave everyone time to do a closing speeches too.
You see these emails between you and Clayton dated June 28th of 2023, correct?
Correct, but the middle email is missing from him, but correct, yes.
You're move for the admission of Exhibit 56, please.
But it's missing
Section
the
56.
middle
Yeah, Your
email.
Honor, I'm going to object because this isn't everything in whole. You can see that there's an email missing between these two emails. There wasn't any foundation that was laid.
But this was one of many emails sent between the two of us. Clayton changed his mind many times.
So I'm just referring to these exhibits. Do you recognize these exhibits? These messages?
I mean, that's what they said. I haven't gotten to read through them, but I mean, that's what it says.
Do you believe these are a representation of the exhibits or of the emails that were sent?
I know that my name when I email somebody else has a picture of me with a horse instead of the LO. So I don't know if that's relevant. Whereas like Clayton's picture is shown with Clayton Eckert. So I don't know if that's relevant. If I read these quickly, I can see if they are mine. I'm going to trust that they are
she's
mine.
stalling.
But, I haven't gotten a chance to read through them.
Your Honor, she did testify that she recognized these to be emails dated June 28th of 2023. So I'm asking for their admission.
Again, the middle email is missing where Clayton tried to trap me, but
I'm asking if the court strike that. There's no question before her right now regarding that.
I'll strike that statement. I will go ahead and admit Exhibit 56.
Yep.
In Exhibit 56, Ms. Owens, on line 1, you say, I just need clarity as to what we are doing. I've offered to give you control over the outcome of the pregnancy if we date exclusively and care for each other, correct?
Correct, which was one thought on one day, and I took that away after, yes.
And this is the exact same statement that you made to Mr. Gillespie back in July of 2021, isn't it?
I have no idea what statement I made to Mr. Gillespie, but both pregnancies have been medically proven, and I have the documentation and sent it.
But Ms. Owens,
All right, we can't keep everyone talking over each other.
I sent the HIPAA records. I released my HIPAA records.
Ms. Owens, there's no question before you. Your Honor, I'm asking the court to strike these statements.
All right, so let's try to just answer the question. If you,
I don't know what I said in 2021.
okay, so if you don't remember, just say, I don't know what I said.
I don't know.
That if I said it. Okay,
I don't
there
know.
we go.
Yeah.
All right, so but we have room for like one more question.
Gulping down energy drink.
And Your Honor, again, I would just ask that in lieu of closing argument that I be permitted to ask.
I've already done that.
Okay.
We're already at 11:56 at the moment. So,
Okay, Your Honor. And here, Ms. Owens, isn't it true that you alleged you were pregnant with twins with Mr. Gillespie in June of 2021?
No, that was an email that he doctored in 2021 that I have already testified about that in the other case. So no, I never said I was pregnant with twins.
Can you please take a look?
Again, this was an exhibit that, whatever it is, I'm guessing I know what it is. It was one message that was doctored by Mr. Gillespie that appeared a year into the court case I had with him.
right, and we've already discussed the fact that I'm not really considering all of that. So let's Mr. Closing.
Your Honor, my concern here, and again, I mean this with all due respect, but Ms. Owens has a pattern of behavior here. She has previously made identical allegations in another case. The exhibits that I have today, supplemental exhibits, all support that the statements she's made to Mr. Eckert are almost identical to statements made to Mr. Gillespie in 2021. This is highly concerning behavior. She has now perjured herself on several occasions during testimony, and I am not being given the opportunity to show the court the documents to support that she is lying under oath.
I have proven my pregnancies and had my records sent to Mr. Eckert.
Okay, Ms. Owens, Ms. Owens, we're not testifying right now.
I'm sorry.
Even if it was true that Ms. Owens did that in the past, which we are denying, But even if it was true, that has no relation to this specific case. Just because she may have done it before doesn't mean she's doing it now. And we have presented evidence showing that she is pregnant. We have presented evidence showing why
That's
she is.
false. There's no evidence
We're going to do
presented.
closing arguments now. So whoever wants to do a closing argument, Serena, go ahead.
Your Honor, this is a clear case of harassment. The court has seen through all of the exhibits submitted by Mr. Eckert and the additional exhibits that we presented today that the parties had an encounter in May of 2020. Mr. Eckert did not have sexual intercourse with Ms. Owens. Shortly thereafter, Ms. Owens began claiming she was pregnant with Mr. Eckert's child, with an alleged child.
Yeah, she claimed that within days, if I remember correctly, which is impossible. In order for a pregnancy test to even be remotely showing pregnancy, you need enough, more or less, here comes what my sisters have told me. So don't take my word for it. But the egg is, what do you call it? Befruktning, sperm meets egg. Then the egg travels down, attaches itself within the, you know what? Then that cell starts to multiply. That takes place roughly within a couple of days, but it needs the time to implant and the body to start reacting to the thing. So we are talking about maybe at least 2 weeks before any pregnancy test. Okay, M1969, about a week later. Yeah, that might be correct. She made the claim, what was it? 2 or 3 days later? Oh, thank you. Here we have it. Stuff that is coming up. 8/11, Arizona versus Laura Owens, pre-trial conference. 8/15. Also the 11th. So Monday. 18th, Owens versus Maracini, DVRO hearing. 19th, Arizona Supreme Court, Owens versus Eckert petition for review. Is that an oral hearing? Because I do think Arizona, if it's an oral hearing, they can actually stream it. Thank you. Oh, people have been asking for the next court dates. So everybody take notice. Take a screenshot if you need to. Or just pause. You can pause as well or write it down. Thank you. Thank you so much, Arthur. Yeah, and what's his face? Gangrel. Ginger ass, whatever his name is DUI pre-trial conference. And as I've heard, he got that DUI in the middle of the night traveling from Laura's Laura Laura only does oral hearings. Oh, that's a good one. Oh, that was a good one. That was a really good one. That also puts us $21 to the next spin on the wheel of regrets. Thank you so much. that was so good. So yeah, Mr. Ginger Ass got a DUI traveling from Laura Owens, roughly in the area of Laura Owens. I guess she didn't pay him with money. Oh, that was good.
Mr. Eckert repeatedly, from May to today's date, has pleaded with Ms. Owens to stop contacting him. He has blocked her number on several occasions, and she gets a new number and or uses an app to continue contacting him. It has not stopped. Mr. Eckert has lost job opportunities, speaking engagements. He has suffered extreme emotional distress over these claims that are baseless and over her repeated outreach attempts after pleading with her to stop. This is the definition of harassment. The court's well aware harassment is defined per the statute as a series of acts over any period of time that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed. And the conduct, in fact, seriously alarms, annoys, or harasses the person and serves no legitimate purpose. Ms. Owens has fabricated a pregnancy now twice on 2 separate occasions. Mr. Eckert is the second victim of this.
And it's more than 2 times.
No medical records to support that she is in fact pregnant. As the court saw, her exhibit 46, Your Honor, is not medical records to support a pregnancy. It is merely, and I'd like to draw the court's attention to this.
Yeah, I mean, just look at her facial expressions. I'm telling you guys, if you look into Laura Owens' background, you will see and you will find theater lessons. Because she cannot do subtlety. She only has these theater reactions. Because that is how she thinks people react. Now, are there some people that always have big reactions? Yes. But Laura, throughout this hearing, has had micro reactions. She has had subtle reactions. She has had normal reactions. But when she believes she has to act absolutely shocked, she does the theater reactions. Now, I'm not a behavior analyst. I'm not a body language person. What I do have is over 30 years experience of sitting on the other side of the desk of business leaders, middle management, HR people. You pick up a thing or two when that happens. Equality says that sounds like sociopathic behavior. I can't say you're wrong. Yeah, as Mo in the deep end says, her face is all exclamation marks. Yeah, Mo only has big reactions. I mean, and she's very, very consistent with it. So, yeah, go watch Mo in the deep end. There you can see when somebody has medium to big reactions consistently.
It is a picture of a test completed at Banner on June 1st of 2023 regarding HCG. It does not say it is a positive pregnancy test. The next page, Your Honor.
Oh, I'm sorry.
This is not your turn.
I'm sorry. It does. Okay.
It's not your turn.
It is very questionable, as a woman who's been pregnant before, that Ms. Owens goes to Banner to get an alleged pregnancy test on June 1st, and then she never goes back to Banner Health for any additional testing. The next page of this exhibit is simply a screenshot of an upcoming appointment with a Dr. McCool on Monday, July 24th, 2023. There are no records to support that she is an active patient with Dr. McCool, that he is her perinatologist. There's nothing. We just have a screenshot of an appointment that was made, which anyone can do online. The next record, Your Honor, this is now a HCG test from any lab test now in Scottsdale. This is not a positive pregnancy test. This is a positive HCG test. Why is she going to a new provider for a alleged pregnancy test on October 16th? These next 2 pages of records, Your Honor, it's hard to tell what they are. They look like they are screen grabs of an appointment that is unclear. It's just unclear. At the root of this case, and the reason that Mr. Eckert is fearful, he is scared, is the fact that there has been a fabricated pregnancy. She has participated in several paternity tests, none of which have come back showing any proof or any signs of fetal DNA, Your Honor. If it wasn't for the fact that she has done this before in another case, this is unbelievable. It is very alarming. She lied under oath, and she lied under oath at the last hearing. She's not being truthful today, and my client is legitimately fearful of what else she's capable of. He's asking that this court recognize that he has done everything to handle this appropriately. He has begged and pleaded with her to stop contacting him. There is no reason for these two to have communication, despite what Ms. Owens will say regarding this alleged pregnancy. There is no proven pregnancy at this point. So we are asking that this court find that she has harassed Mr. Eckert from May of 2023 up until today's date, and we're asking that the court find that the injunction against harassment needs to be ordered and maintained.
Thank you, Mr. Lopez.
Yes, Your Honor. Now, I would agree with Clayton that Laura's communications with him were alarming, annoying, harassing, if in fact Laura wasn't pregnant, and if in fact he wasn't responding to her through the over 4-month period that she's been pregnant. She is pregnant, and he has been responding. Clayton has not met his burden in this matter. He's claimed that the amount of texts and emails has caused him to be alarmed, annoyed, harassed. Well, for starters, the reason there are so many emails and text messages is because the chosen form of communication between Laura and Clayton was through emails and text messages, and because that was how Clayton wanted them to communicate, not in person, not over the phone.
Here again, I've been in different courts. I've been listening to quite a lot of restraining orders, and some things that is very damning to not get a restraining order is replies. If it's not a reply that is stop contacting me, full stop, but it is once in a while a normal message within there, then one of these can be hard to make. Sadly, unless you're a woman. Statistically, women have much easier to get restraining orders, which we know through Laura Owens.
But through emails and text messages. And second, we are talking about a span, again, over 4 months or more. There are going to be a lot of text messages during that time. There are going to be a lot of emails during that time. Third, he claimed in his petition that he has not responded to Laura and that he had blocked her. Now, that is clearly a lie. And
Your Honor, I would object. That misstates the evidence. There is clear evidence to support that the messages are showing from a blocked sender. That is not accurate.
Your Honor, some of those messages may have been blocked, but there are other communications in the exhibit, in Clayton's own exhibits, that show that he did respond to my client, whether it be an email.
Yeah, I mean, that current lawyer she had, who then made the off I fuck motion and off he fucked. He's doing a good job. No question about it. He vehemently, zealously defends his client. And he's doing a good job at it. He has no facts to him. So he doesn't really point to facts unless he can find a handful of messages from Clayton that isn't leave me the fuck alone.
Emails or text messages, and we've provided those some of those exhibits in the ones that were admitted to this court. Now, Laura testified that there was communication, even aside from the exhibits that we've presented. It's impossible to put all the communication within over 4 months into a short hearing, essentially. Now, I want to talk about the content of that communication. All of the communication from my client to Clayton was meant for legitimate purposes and not to annoy him, not to harass him, not to alarm him. Almost all communication between Laura and Clayton was for the purposes of the pregnancy and paternity. The only other sort of communication from my client toward Clayton was in relation to the post that he put online when my client would receive harassing messages from Clayton's fans and his followers. So the communication around that time, call it August, September,
was toward Clayton, asking him to take those different things down so that my client wouldn't be harassed. Throughout this entire time, since May, Clayton has never been clear with what he's wanted to do. He's been wishy-washy the entire time. First, he didn't believe that my client was pregnant, so she sent him proof, and she sent him proof again. He wanted numerous forms of proof. You saw in our exhibit the video of Miss Owens pregnant. That was a video that Clayton asked my client to send to him. How can you ask someone to send you proof of their pregnancy and then now call it harassment? Now say that you're alarmed. Now say that you're annoyed. Now say that you're harassed. That doesn't make any sense. He was also wishy-washy about what should be done with the unborn children. And we're talking about at the beginning, around May, June. Should she have the children? Should they be aborted? Are we going to give them up for adoption? Am I going to have sole custody? Is she going to have sole custody? He was never consistent with what he wanted. I'm sure maybe he thought one thing one day and maybe he thought something else another day, and then he thought back to we didn't know what he wanted. And that was communication that was going both ways, back and forth between Clayton and Laura. Again, he hasn't been consistent, and that is what the root of this problem is. That is why there's so many communications back and forth. Had this been done in person, had they chosen to meet up physically or talk over the phone, things wouldn't get lost in translation through email, through text. But that's how Clayton chose how he wanted communication with Laura. And that's what made everything so difficult. During this time period, Laura actually had to hire another attorney to help facilitate paternity testing. That didn't work, so then Laura had to file a matter out of the family court to create a parenting plan.
These are not facts and evidence at this time. These are exhibits that Mr. Lopez did not get to present.
I think she testified that she filed a paternity lawsuit.
And they did not have, neither of them, my client nor Clayton, have had an attorney in that family matter, so they are forced to communicate with each other because they needed to meet and confer. They needed to submit a resolution plan, so there's going to be text and communications back and forth from the two of them. Everything that you've heard during, whether it was our case in chief or the petitioner's case in chief, this is a snapshot of what has happened over the course of over 4 months. We were not able to present everything. All communication between my client and Clayton were for legitimate purposes. Again, not to harass him. Look at the exhibits. Look at the ones that Clayton submitted. There are clear exhibits that show that he was sending messages to her. We had submitted exhibits showing that Clayton had been communicating with her. So the fact that in the petition itself states that he had not responded to her, that's completely untrue. He had indicated in his petition that my client had harassed him. Well, that's not what happened. Who was the one that was posting videos online and getting harassed? Clayton was posting the videos. My client was getting harassed. Not one communication. There wasn't one communication that indicated after they had been in communication since May. Since then, there was no communications that were sent to my client telling my client, stop texting me, stop emailing me, stop calling me. Not one. They presented one exhibit that shows one message that indicated that, oh, I may call the police, something like that. It seems like he might be worried. But since then, he had been communicating with my client. So again, you can't say that you are being alarmed, annoyed, harassed, but then going ahead and then emailing.
Here's the thing. If neither of them have an attorney in the paternity thing, yes, they are forced to communicate in court. But the only communications that they have to have outside of court is legal documents.
My client, texting my client. And again, for all of those reasons, I think that the communication between my client and Mr. Eckerd were for legitimate purposes, for the to determine pregnancy itself, moving into determining paternity itself, to trying to schedule paternity testing with the attorney, to the family court matter, and to today. And so for all those reasons, we're requesting that this be dismissed. Thank you.
Your Honor, in rebuttal, none of the communication from Ms. Owens to Clayton has been for a legitimate purpose. As the court has heard today, it is clear there has been no DNA test or test of any kind to support that she is allegedly pregnant with Mr. Eckerd's twins. There is no reason for these parties to communicate. What Mr. Lopez is proposing is that if you block someone, but they find another way to contact you, and then you tell them you still don't want to talk to them in a polite email
and the
polite
faces,
message, then that's not harassment. That is the epitome of harassment, Your Honor. The court has received exhibits in the first hearing from Mr. Eckert supporting that she would find other avenues to communicate with him after he had blocked her. Again, it is Mr. Eckert's position that that this pregnancy has been fabricated. And I want to be clear on this, Your Honor. It's possible that Ms. Owens is pregnant, but it's my client's position that he did not have sexual intercourse with her and she is not pregnant with his alleged twins. And that is the root of the issue here. There has been no support for this alleged pregnancy other than her attempts to show the court and or Mr. Eckert a picture of her alleged pregnancy, which again, we suspect may still be fabricated. So there has been no legitimate purpose to her communication other than to harass Mr. Eckert to try to force a relationship on him. She told Mr. Eckert on multiple occasions that she was going to force him to communicate with her, whether he wanted to or not. And he has been clear. He does not want any additional communication from her.
All right, thank you. So, as I stated when we first started this hearing,
and she's gulping
I'm not
monster
making
drinks.
a determination as to whether or not she's pregnant or not. That is a family court matter. That case is pending before the family court. The testing or whatever is going to happen is a result of that. So I'm not making a decision and a determination today whether or not there is a valid or invalid pregnancy. I understand Mr. Eckert's position is there isn't. I understand her position is there is. That's where we are at the moment. With regards to the evidence and the communication, the court at this time does find there were a series of events that were aimed at the plaintiff that would cause a reasonable person to be alarmed, annoyed, or harassed, that he was in fact alarmed, annoyed, or harassed. I do find they did not serve a legitimate purpose. Messages that have been sent, one, he blocked her on numerous occasions. She even said in the blocking communication, can you unblock me so I can unblock you again? I got a new number and then there's another new number. I think that's clear that he does not wish to have communication. Nature of the communication, while maybe surrounds the pregnancy, the communication that I have a lot of concerns with are the ones where she's trying to make offers to him to continue a relationship, that she is trying to facilitate. If you do this, then I'll give you this. Those kinds of messages are of the nature that are harassing and can be.
Look at the hate in Laura Owens' eyes when the judge does not agree with her. She can't hide it because she's an entitled bitch who can't take no. If Laura Owens were a man, she would already be in prison. Statistically. But that is pure hate from her that the judge does not agree with her.
Viewed as alarming, annoying, or harassing. There are a number of messages that were admitted that are attempts that I view kind of almost as trying to, get him to do and agree to things that are not necessarily, it's not like we said, hey, can you take the attorney test? And he said, no. Hey, can you reconsider? I want to do a attorney test. And then I went and filed a lawsuit because you wouldn't do it. I mean, that's one thing. 500 emails back and forth, or messages, I'll say text messages and emails over that period of time to try to clarify and do that is beyond what was necessary to be able to communicate those things. There were a number of threats to go to the media, which were other additional attempts to try to use the media as manipulation, or the threat to go to the media as manipulation. I find those to be alarming, annoying, or harassing. So I am going to grant the injunction at this time. The injunction is going to prevent any communication outside of the legal process. And specifically a legal process and court hearings. So I am going to grant the injunction. And so I will sign the granted injunction today. And then I know Ms. Owens isn't present, but we can give a copy of the signed injunction, obviously, to Lopez today, but whether or not ultimately she needs to be served with it so that.
Yeah. Yeah, I can't disagree. Because her demeanor the entire hearing that we watched earlier and this one has all about being her portraying herself as a victim. The judge now tells her, "Go fuck yourself. I'm not buying it. She's getting this injunction." And she hates it. She absolutely hates it. And she can't hide it.
The service of the injunction is appropriate. So it will go into effect.
Oh, and by the way, have you noticed that she's not trying to stand up and show her belly this time?
Once the injunction is served upon her, it would remain in effect for a period of 1 year. This was the hearing that she had as a result of that. So there's not an additional time to request an additional hearing. And if you guys want to wait for a few minutes, I'll sign an order. If there were exhibits that you did not offer that you wish to have returned to you, you can let the clerk know and she can release those back.
Thank you.
All right, thank you.
Thank you.
Oh, she hates this. Oh, Julio again. Thank you. Thank you so much. That is so nice of you. Did you hear the timer? Her bun is boiling. She needs to go. Do I still have that thing here? Oh, damn, it's not here. I used to have a bell here. Nope. Can't find it unless it's not there. Darn it. I will use this instead. Let's see if the batteries still work. Oh. Yes, I have disco lights. Thank you so much, Julio. Putting us to $16 to the next spin on the wheel. But we are very close to the end of this stream because we're closing at the end of this hearing.
I need to hear another too.
Yeah, she's Glenn Close 2023. Oh, that took care of it. Oh! All right. Wow, that took care of it. Definitely took care of it. Thank you to Julio for $20. And Connor is here. Hey, Connor, $16. Thank you, thank you, thank you. Thank you, both of you. One saying cheers, one saying take my money. Yeah. I mean, in about a month, I will be meeting with Connor. If you don't know, Vice Baby is Jeff, Legal Vice's kid. And we will meet up when I get to Utah. I can't wait. I wish it was different circumstances, but I'm very, very glad to be sharing a screen with him and soon to be, well, sharing a memory with him in Utah. But all right, that took care of that, which gets us to the next spin on the Wheel of Regrets. Not hot sauce. I will respin. Of course, it's another gin shot. Jesus Christ. And it's another gin shot. I have my Kentucky shot glass. When I get to Utah, I will buy a Utah shot glass. I don't know if you have shot glasses in Utah because your alcohol laws are stricter than Swedish ones. But if you have one, I will buy one. Cheers. Oh, now it's nice, but I prefer this one in a gin and tonic with tonic. There are shot glasses, don't worry. Okay. Somebody asked me last year, why don't you buy beer glasses? Because I need to get them back. And shot glasses are easier to fit in the trunk. All right, what do we have left on this one? It's just the signing, I guess. Okay, this is just then Tom.
And then I was like, oh.
Oh yeah, there in the background. Oh, sorry. In the background, you see the other people who is there with him. Mr. Gillespie, was it right? Oh, yeah, I have the chat in a way. Yeah, and off she fucked, and off they fucked, and that was that. Folks, it has been an absolute pleasure to share this moment with you guys. I'm having way too much fun with the Laura Owens case. I'm glad I'm being able to share this with you. Me getting caught up. Now I know because I watched Jeff back in the day. I watched Megan Fox when she has her streams, but I haven't covered it. And now with the state charges, I want to be fully caught up when that goes to trial, because it will go to trial. I can almost guarantee it, because Laura Owens will never admit she is wrong. And when that trial happens, which I mean, they are having hearings now, so we are probably 6 months to a year away from being close to the trial. It's going to be amazing to cover it. Absolutely amazing. So welcome, folks, to me. I'm Nick Starrow, Trial Watch, legal snark with snark attacks. I might use words you're not used to on other streams, and I'm proud of it. Other cases I cover is the Delphi trial transcripts. You will see me reading those tomorrow, starting around noon and going for a few hours. Those are gnarly. Those are absolutely gnarly. Those have, it's a trigger warning on those. I covered the Delphi case for over 2 years, and I'm having difficulty reading the trial transcript. Also covering the Donna Adelson case, that trial starts August 19th. So you will, there's always something to watch here. And go watch my older stuff. I have a bunch of shorts and videos with where I'm having way too much fun again. So again, oh, Pam, new subscriber. Thank you so much. Thank you so much. And apparently there's a hearing on Monday. I don't know if it's going to be recorded or streamed. If it is, I will try to at least, because I'm going to read the trial transcript on Monday for a few hours. And then I will catch up on the Laura Owens hearing. Maybe not live, but at least as a recap. All right, folks. Again, thank you so much. And I'm going to send you off with a new Suno song. So me and Mr. Jingles here. Thanks you. And we're going to send you off with a new Laura Owens song. Thank you again. And remember, folks, hug your family. Unless your family is shit, then screw them and give your love to the people who deserve it. See you tomorrow. Bye-bye.
Laura's got a secret, oh what a tale. She spins a wild story, set to sail without a sail. Fake baby bumps, she's got tricks up her sleeve, but the boys see through it, they just can't believe. Oh Laura, 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 what did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise. Points her finger, you're the bad guy now. But truth's got legs and it's taken a bow. Her plans unravel like a thread on a spool. Life's not a game and you're breaking the rules. Lies and lawsuits, so what a show. But justice is coming, it's starting to grow. You can't win hearts with tricks or a fight. The truth shines brighter than a starry night. Did you do? Play and pretend just to make it through. The boys fight back, they're standing tall. Laura's big surprise is no surprise at all. So kids, remember, don't twist what's true. Life's much better when you just be you. Laura's learning the hard way it seems. Honesty's the hero in everyone's dream.